Criminal attempt to commit armed robbery. All right, so I can receive. Got it.
Mr. Rhodes?
Which one? There's several. Oh, okay, yeah, sure. I can.
This is the one from October of 2020.
And I'll
This is
also
just
put
count 1 and 2.
the case number
Aggravated
that I'm
assault
dealing with on the record
on
too.
Jakari
So
Williams, shooting at Jakari Williams. Yeah.
that should kind of narrow things down.
Count 3 is not involved here.
He's over here, he's position 2. He's position. He's position 4. And he's position.
And this is the one involving Anaya. Is that
Second.
Anissa?
2, 4, and 7.
Ayana.
Yes, 2, 4, and
I'm
7.
sorry.
Okay. Thank you.
So leaving under Alfred. Sorry.
On this one.
It's all 3. Yeah. This is the one we talked about biting her and then pushing her out the car. It doesn't involve a firearm, so it's not as. And like I said, you're not admitting you did it, you're just leaving under Alfred to get the case closed. All right, you okay with that? All right.
2, 4, and 7. Just remember the out of position, it was not false, it was indicted.
Ms. Hall, did you ever text me?
What did you say?
Did you ever text me?
Oh, no, I'm sorry. Disregard. I changed my mind.
Okay. And which counts on this indictment?
1 and 2.
Okay, so you're dismissing count 3?
Yeah, it emerged into
Okay.
1. So.
Then I think. I'm gonna get the other 2 up here.
We can just pass it out. Here you go. Just let me know when you would like me to start.
All right, let's go.
Okay. So, Your Honor, we're here this morning in the case of State of Georgia versus Demetrius McDowell Jr. It's case number 24 SC 002147. Mr. McDowell, can you please raise your right hand for me? Do you solemnly swear or affirm that the testimony you shall give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay, and make sure you're speaking into the microphone so the court reporter can take down everything you're saying, okay?
Sure.
Yes, ma'am.
State your true, correct, and legal name.
Demetrius Antoine McDowell Jr.
Hold on, Miss, yeah, you don't have to lean real close, you just have to speak up, son.
Demetrius Antoine McDowell Jr.
Are you currently under the influence of any alcohol, drugs, or taking any medicine that affects your ability to understand these proceedings?
No, ma'am.
How old are you?
30.
How far did you get in school?
11th grade.
Did you complete your GED by chance?
No, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses? Counts 1, 2, 3, and 5 charge you with violation of the Street Gang Terrorism and Prevention Act. They're each punishable by 5 to 20 years in prison. Count 8 charges you with murder. That's punishable by life in prison. Counts 9, 10, 11, 12, and 14, they charge you with felony murder. Those are also punishable by life in prison. Count 17 charges you with attempted armed robbery. That is punishable by 1 to 30 years in prison. Count 18 charges you with attempted purchase of marijuana. That is punishable by 1 to 5 years in prison. Counts 19 and 20 charge you with aggravated assault with a deadly weapon, punishable each by 1 to 20 years in prison. Count 21 charges you with home invasion in the first degree. That is punishable by life or 10 to 20 years in prison. Count 22 charges you with possession of a firearm during the commission of a felony. That's punishable by 5 years in prison. And finally, count 24 charges you with possession of a firearm by a first offender probationer. That's punishable by 1 to 10 years in prison, for a total maximum exposure in prison of 2 life sentences plus 70 years. Do you understand that?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you will receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Melnick, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any more time to talk to Mr. Melnick about the case?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Melnick, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
I'm not, yes.
Mr. McDowell, has your attorney advised you of the minimum and maximum sentences for each charge you were pleading to, just as I advised you a minute ago? Everything I
ma'am.
went over. Did you also go over that with Mr. Melnick?
Yes, ma'am.
And did you understand everything that he told you?
Yes, ma'am.
Do you understand that neither the court nor the DA's office has anything to do with parole or the Department of Corrections or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you to the contrary?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be the following sentence? Count 1, participation in criminal street gang activity, 12 years to serve in confinement. Count 17, attempted armed robbery, 30 years to serve, 12 years in confinement with the balance on probation. That's going to run concurrently with count 1. We are tendering a null pros to the court for all the other charges, meaning they're being dismissed. The terms of probation will be as follows, Mr. McDowell. You are to testify truthfully at any subsequent trial in accordance with your statement to Investigator Malone. The statutory gang conditions, which are no more criminal street gang activity and no more contact with any member or associate of any criminal street gang. Also, no contact with the victims, family members, co-defendants, and the incident location. No possession of guns or replicas, a Fourth Amendment waiver, no drugs or alcohol, and also no possession of any gang paraphernalia. We are agreeing to run this concurrent with your other 2 cases, 23 SC 189047 and 23 SC 187394. Yes. Mhm. The numbers?
And we go through all the charges. We do it all together so that they don't have, so they won't have to go.
Each individual
Sure.
case, yeah.
So I don't.
I'll jump in.
You can just go through hers and then Mr. Brown
Miss,
can go through his.
no, it's gonna take longer. Ms. Hall?
Hmm?
Can you?
I'll jump in. Ms. Murdell, in indictment number 23 SC 189047, do you understand that you've been charged with 2 counts of aggravated assault, family violence?
Yes, ma'am.
Do you understand that the minimum and maximum for aggravated assault, family violence. The minimum is 3 years to serve and the maximum is 20 years to serve.
Yes, ma'am.
And do you understand that the maximum on these two counts would be 40 years? And the maximum exposure for you is 40 years to serve.
Yes, ma'am.
That's all for that case, Ms. Woods.
Ms. Hall, could you go ahead and do the next case for me while I get Mr. Brown?
Yes.
Thank you.
And then, sorry, I didn't have that one pulled up.
It's,
Is,
You-
is it
the-
just the aggravated assault, possession of firearm?
That's
and
correct.
Possession of firearm by felon?
no, that count 3 doesn't apply to
Okay.
Mr. McDowell.
So just
it's
the first
counts
one
one
at a
and
time,
two.
So Mr. I can do it, Ms. Hall. So Mr. McDowell, in case 23 SC 187394, on count 1, aggravated assault with a deadly weapon, the exposure is 1 to 20 years in prison. On count 2, possession of a firearm or knife during the commission of a felony, that is a 5-year consecutive for a total maximum exposure of 25 years. Do you understand that, sir?
Yes, ma'am.
You have to answer all that, yeah. So the total exposure for all 2 life sentences plus 135 years.
Do you understand that, sir?
Yes, ma'am.
And Ms. Hall, do you want to go ahead and put your recommendation on the record?
Yes. Mr. McDowell, do you understand that from the state's recommendation, this is a negotiated plea of guilty, which means the state will recommend to the court a sentence for count 1, aggravated assault, family violence. The state's recommendation is 5 years to serve to run concurrent to the other 2 cases. And for count 2, aggravated assault, family violence, the state's recommendation is 15 years to serve 10 years, balanced on probation. Special condition that you have no contact with the victim is, in this case, Miss Ayana, Ayana, last name Williams. No contact with her, but the judge does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
And just so that we are clear for the record, those sentences will run concurrently with the sentences in the 2 other cases
Yes,
And-
and concurrent to each other.
and concurrent to each other. And this is a plea under Alford versus North Carolina.
Understood.
You want to go ahead and put your recommendation on the record?
Sure. So on, and forgive me because I don't know the SC number, but with the 2 cases that Mr. Senior and Junior have, position 1 and
I think it's 2.
so
So this is it.
gotcha.
Who is mine?
Indictment 23 SC 189047.
That's mine.
187394.
Yeah.
Number 4. Okay. Right here.
23 SC 187394. And with respect to that, the state offer would have been 12 or 10 to 10 to serve. I think it was 10 to serve
10 to serve concurrent with the other 2.
with the other 2.
Yes.
And what's happening with the gun charge?
The gun is 5 consecutive suspended.
Thank you.
Okay. So, Mr. McDowell, do you understand, however, that the court does not have to accept that recommendation, that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated pleas, you would have the right to withdraw the pleas?
Yes, ma'am.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, it may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
What was that?
I said yes, ma'am.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, ma'am.
In addition, you waive the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to a court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges following a trial. By pleading guilty today on the 3 indictments, sir, you're waiving or giving up all of the rights that I just enumerated to you. Do you understand that?
Yes, ma'am.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea to these 3 charges,
No, ma'am.
to these 3 indictments? Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
So just for the record, Judge, on the 24 indictment, the multi-count indictment involving the murder case, I think it's 24 SC 002147 or 2. That is an offered plea, as well as the case involving Ms. Hall, 23 SC 189047.
Larissa, we should probably take those individually.
Sure, yeah. Okay, so Mr. McDowell, as to 24 SC 002147, that's my case involving the gang charges. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this guilty plea places you in the same position as if you were convicted by a jury at a trial? Do you understand that?
Yes, ma'am.
Okay. So in that indictment number ending in 2147, sir, how do you plead?
Guilty.
Guilty.
Guilty pursuant to Alford?
Yes.
Yes, ma'am.
Okay. So in the second case number, 23 SC 189047, are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this guilty plea places you in the same position convicted by a jury at a trial?
Yes, ma'am.
So in that case number, sir, how do you plead?
Guilty.
Pursuant to Alford? Is that a yes?
Yes, ma'am.
Okay. Now, in the remaining case, 23 SC 187394, how do you plead? Guilty or not guilty?
Guilty.
Are these guilty pleas freely and voluntarily given with the full knowledge of all the charges against you?
Yes, ma'am.
And do you understand that you may have only a limited right to appeal these guilty plea convictions?
Yes, ma'am.
Do you understand that unless counsel is substituted or permitted to withdraw, Mr. Melnick will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, ma'am.
Do you understand you have 30 days from the day of your sentence to file a direct appeal?
Yes, ma'am.
And do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition, which is essentially a legal term addressing your ability to address any constitutional defects or challenges to your guilty pleas?
Yes, ma'am.
Do you understand that you have until the last day of the current term of court to file a motion to withdraw your guilty pleas?
Yes, ma'am.
And do you understand that any of these filings we have just talked about must be filed by your attorney unless you are representing yourself?
Yes, ma'am.
Paul, before I get into my factual basis, is there anything you wanted to add that I may have missed pertaining to your case?
No.
Your Honor, the factual basis for 24 SC 002147 is as follows. On April 12th, 2023, at approximately 11 at night, armed robbers, this defendant, Demetrius McDowell, the co-defendant who has since pled guilty to 30, served 15, Keontae Jackson, and the third co-defendant, DeMonte McNabb, fatally shot their co-assailant, Calvin McDowell, who is the decedent in this case, in the driveway of 1591 Woodland Avenue in Southeast Atlanta. Terrence Malone was assigned a lead detective in this case, Judge, and he interviewed the victim of the attempted armed robbery. His name is Jarquavius, Jarquevious, last name Everson, Everson. He spoke with him. It was actually Mr. Everson's home where the incident happened. And Mr. Everson explained that just prior to the incident, he and a friend by the name of Roderick Butler, first name is Roddrick, they were at Everson's residence playing video games when they heard a knock on the back door. When they opened the door, he observed the decedent Calvin and two other men. The two other men were unknown to him, although he did know Calvin. Mr. Everson said that he and Calvin had previously negotiated the sale of 3.5 grams of marijuana. And when Calvin arrived to make the purchase, he began to prepare the marijuana. Everson stated that as he was preparing the marijuana, Calvin brandished a weapon and attempted to rob him. He brandished a firearm. Everson said that he ultimately tried to disarm Calvin, and during that struggle for control of the gun, one of the other co-defendants, either Mr. Jackson or Mr. McDowell, they essentially opened fire. Mr. Everson explained that he was successful in getting the firearm from Calvin, who subsequently crawled out of the back door as the other two, this defendant and Mr. Jackson, continued to fire shots towards the home as the decedent was struggling to crawl outside. Mr. Everson explained that he suffered a gunshot wound during the initial volley of gunfire, and after the gunshot stopped, he secured his residence and then went to the hospital for treatment for his gunshot wound. Mr. Everson then explained that although he did get Calvin's weapon, he was never able to let off any shots. So the shot that killed Calvin would have come from one of the co-defendants, namely either Mr. McDowell or Mr. Keontae Jackson. Detective Malone found two abandoned cell phones, and he examined the data within those cell phones. He found that one of those cell phones belonged to the decedent and the other belonged to this defendant, Demetrius, who also went by the name Lil Meat, common spelling for both. Detective Malone reviewed the call logs within this defendant's phone and found that the person who he last communicated with before dropping his phone during the escape from the home was someone by the name of a Miss Edwards. She told Detective Malone that this defendant, Demetrius, was the person who she communicated with on that cell phone, thereby evidencing that he was in fact inside the home during the course of this attempted armed robbery. She identified him via a single photograph. Detective Malone also found a second number in this defendant's phone that belonged to a person by the name of Miss Williams. She explained that Demetrius was the father of her child, and since the fatal shooting, Demetrius admitted to her what had taken place, and he said he had residence with the decedent and the co-defendant Keontae Jackson, and he admitted to entering the home during the course of the armed robbery. He then said that they left Calvin's body at the home because they couldn't really find him after he had been shot. Detective Malone also learned that a person by the name of a Miss Seaborn was likely the last person to speak with Calvin before the shooting. And during Detective Malone's interview with Miss Seaborn, she admitted that Calvin had come to her and expressed an interest in going to the incident location to commit an armed robbery. After this defendant was apprehended, Detective Malone saw that he had a GPS ankle monitor on, and that placed him again at the crime scene. He also gave a statement and placing himself there and also placing co-defendant McNabb there, as well as co-defendant Jackson. The crime scene tech, Your Honor, found multiple shell casings at the crime scene, 12 7.62 39 spent shell casings and 11 9mm spent shell casings. This defendant, Mr. McDowell, is associated with the national criminal street gang, the Bloods, by way of a subset called Sex Money Murder. Mr. McDowell has a B tattooed on his face and has been seen on social media using language characteristic of the Blood Association, as well as posing with numerous guns and large stacks of money. PDE is a hybrid criminal street gang based in DeKalb County, and the name stands for Paper Drugs Extortion or Paradise East. The decedent was a member of the Blood subset Paradise East Judge and also a subset of that criminal street gang, One Gang. And the co-defendant Keontae Jackson is also a member of PDE. And PDE is known to commit these violent kinds of crimes, like murders, aggravated assaults, and also armed robberies. And all events occurred in Fulton County. I would like the record to reflect, Your Honor, that the murder charge in this case is being dismissed, taking into consideration the fact that the person who ultimately died was a relative of this defendant. I believe he was actually his brother. Also, they were in the course of committing a violent armed robbery on this drug dealer, which is another reason why we believe that the negotiation here is appropriate. Because had the decedent survived, he would have very well been a co-defendant on an armed robbery indictment. I also would like to place on the record that Miss Earlene McDowell. Miss McDowell, can you stand up, please? Oh, she's on that side, okay. So she is the mom of the decedent in this case, Calvin McDowell. And she just wanted the court to know, I spoke with her this morning, she just wanted the court to know that this incident has tragically torn apart and affected her family. She told me that she's lost about 50 pounds since everything happened, just dealing with the fact that one son is deceased, and I believe this is also her son, and he's standing right here before this court. I explained to Miss Earlene McDowell that, you know, it's a tough situation to be in, but something has to be done. I couldn't just very well let him walk out the door with straight probation, Your Honor. So one more thing for Mr. McDowell. Mr. McDowell, you remember giving a statement to Detective Malone, sir, during the course of this investigation on the day that you were arrested?
Yes, ma'am.
And are you affirming that statement to be true today on the record?
Yes, ma'am.
Is that a yes?
Yes, ma'am.
Okay. And Judge, I believe that is all I have.
Judge, there's a lot that I could get into in this case. This
Wait.
is all a negotiated disposition. I'm sorry. This is a negotiated disposition. I will say Earlene McDowell wants less jail time or no jail time for Demetrius McDowell in this case. And one of our primary motivations for taking this plea is the fact that we're not just resolving this case, which had a lot of factual issues, I think, from the state's perspective, but also the other two cases as a global resolution. So I am asking that you accept the negotiated dispositions that we've reached in this case and for the other two indictments that are present before the court today.
Ms. Hall?
Yes, Your Honor. And have we proceeded to trial on 23 SC 189-047, the state would approve beyond a reasonable doubt that on March the 26th, 2023, this incident location that was used was 195 Fairmont Road. That is the victim's address. However, the more accurate location would be the model station on Martin Luther King Drive, which is in Fulton County. The defendant and the victim in our case, Ayanna Williams, they were in a car together. A dispute happened. In the middle of that dispute, the defendant is driving the car at that time. He reaches over and he starts to assault Miss Williams. At some point, he leans over while he's driving and he bites her. And then didn't stop there. He ended up pushing her out of the vehicle while it was moving. She ended up walking to her grandmother's house, and at that point, she called 911. When she made it to her grandmother's house, officers arrived. They were able to see visible injuries to her face. She had bruises on her chest. You could tell that she had been on the ground. Obviously, they didn't see her get pushed out the vehicle, but they could see that she had somehow had contact with the ground. She did have a large bite mark on the side of her face as well, which corroborated the information that was given by Ms. Williams. The defendant, there was a warrant taken out on the defendant. Obviously, he was arrested and charged accordingly. I have spoken with the victim, Ms. Williams, in this case. She is still having some residual recovery from her injuries from being pushed out of this moving vehicle. She doesn't want to have any contact or anything to do with Mr. McDowell. She says she has moved on with her life. She does think that he needs time incarcerated to reflect on his actions. But other than that, Your Honor, that is all from the state.
Anything else? Mr. Brown?
What's your factual?
On, if this case was to proceed to trial, the state would expect to prove beyond a reasonable doubt that on October 24th, 2020, victim Jakari Williams was shot twice by the defendants, Demetrius McDowell Sr. and Demetrius McDowell Jr. Mr. Williams was inside of the residence and noticed a cream-colored Toyota Camry and a silver Nissan Murano or Rogue that had been circling the residence. He recognized both of the drivers as Demetrius McDowell Sr., aka Big Meat, and Demetrius McDowell Jr., aka Little Meat. Mr. McDowell Sr. And Jr. live at the adjacent street on Florida Avenue and Windward Drive. The defendant stopped in front of the incident location and asked for some substance and said they were looking for a gentleman who was selling a car that lives there. Witnesses witnessed that that both defendants were asking questions about the vehicle. Witness Shelton stated to the police that after the questions, both defendants began shooting at the front of the location, which was 243 Florida Avenue Southwest in Fulton County. Witnesses saw both defendants began shooting at the location, striking the victim, Jakari Williams, twice in the forearm. Police were called and the victim was transported to Atlanta Medical Center with heavy blood loss.
Anything else?
No, Your Honor. As I said, this is negotiated as to all three cases. We would ask that you accept it.
Anything else from the state?
Your Honor.
Nothing further.
All right, so for position 2, 23 SC 189-047, I'll accept the negotiated plea. No further contact with Ayanna Williams. No drugs, no alcohol, no weapons, no replicas of weapons. You got to stay away from MARTA, bus, trains, planes, automobile, anything at MARTA, okay? Did he live somewhere outside of Fulton County when he gets out?
I don't know, Judge. I'm pretty sure he's gonna be in Fulton County. That's where his mom lives.
All right. Let's see, on number 4, 23 SC 187394. I'll accept that, no further contact with Corey Williams, no drugs, no alcohol, no weapons, no replicas of weapons. I'll accept that as negotiated plea. And number 7, 24 SC 002947. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. No, yeah, as you said before, no contact with anybody that's a member of sex, money, murder, CDP, or any other gang or affiliates. No further contact with Keontae Jackson. Previous Everson, Roderick Butler. In social media. I would say no further contact with victim's family, but unfortunately, that's your family.
That's his family, so, yeah.
Will testify at trial truthfully, and you're saying right now that the statement you gave, statement in this case was true and correct.
Yes, ma'am.
I'll accept this plea also, I'll accept all of this free and voluntarily. Given the press and been properly advised on Mr. Melnick, Ms. McDowell, I hope that Calvin's memory brings you, comfort. And his memory should be a blessing, and I'm sorry for your loss in both instances, okay? All right, best of luck to you, best of luck to you.
Your Honor, if I may, there was a Fourth Amendment waiver as well on 2147.
All right, and that Fourth Amendment.
Thank you.
The time that he has served in custody, Judge, yes. All right. Thank you.
All right, thanks. He's my other.
I've got him here, but the state needs to sign him.
Mr. Brown can sign one of them and I'll sign the other.
Okay.
I need to write.
Okay, because that's the only other thing I have.
Hold on to these.
But I can't do that while you guys are doing, please.
Yeah, both of these are Mr. Brown. Where's Mr. Brown?
There's a lull right now. Go back right now.
Good feeling. Are you guys bringing somebody out?
Is this guy, real quick? McNabb.
You need to talk to him?
McNabb, yes.
Yeah.
That would be-
And then I gotta go back to,
The next person, I'm about to.
Okay, we gotta have.
It won't take that long. Get him in here. No, you're back. Which one we doing?
Yeah, I said, well, let me know. And here's Brandy, follows Brandon. Thank you. And then, after that, I have a few with Mr. Wright. Okay, Mr. Hudson is on.
Let me link to that.
And then I have and then, all of Ms. Paul's.
See ya.
My understanding of the Hosley, Matt,
I had to talk to Mac, right? I haven't gone back to talk to him real quick.
No. No. I'll grant permission to sign your names.
Yes, or Deputy Hodge can sign it. She's standing right there.
Oh. Here you go. It's, you want my pen? I got you real clear.
Bring me back.
It's my pen. I love them. I'm being out of here.
Okay, but like, what?
Oh, was it one court watch? Yeah,
He's what?
basically, we have like now.
No context to talk about.
Gets spicy.
Are those?
No, yeah.
And the other, you mean all of them?
He said it really. But he can get invited in my when you get out, when you get out, when you get out, can you hurt it? Yeah, I think so.
He's in bed.
I mean, he probably won't. Maybe I'll do it to his friends, just. Even maybe you don't go for the burn. Anytime I do that one, I see it. I don't know.
Maybe, no, maybe I did. What's the date?
Yeah, I don't understand.
No, thank you. I got it.
Okay.
I think you said this before.
Yes.
Yeah.
So all the people that they football. Yeah. So that girls get some of them. It's very. Very nice. And maybe other street. Okay, usually you say no, that's the new book. And he is. They cross over.
Other than.
So. And all right. All right. Oh, I'm good. Okay, so we're going on this mom's reservation. Please help there. Okay. Okay. Oh, the drill was. Right, yeah.
You don't got it.
Don't they count?
Oh, wow.
Yeah.
This one is.
30.
I think you can find it.
It is. No, ma'am.
Ready, number 30, Liza Oliver, 24 SC 00473.
Mr. Oliver,
Yes.
please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
State your true, correct, and legal name.
Elijah Nathaniel Oliver.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
27, bachelor's degree.
Are you able to read?
Sorry.
What was that?
Associates.
Associates? Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged with the following offenses? Fleeing and attempting to elude under OCGA 46-395A, driving under the influence of alcohol less safe, OCGA 46-391A1, and reckless driving, OCGA 46-390, and speeding, OCGA 46-181.
Yes.
Okay. Have you reviewed these charges with your attorney? And have they advised you about the potential minimum and maximum sentence for each charge you are pleading to?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Ben Mazingo, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this with your attorney?
No.
Are you satisfied with his services?
Yes.
Do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 30 days to serve, credit for time served, balance probated, and a $1,000 fine for count 1. Count 2, 12 months probated to run consecutive to count 1, credit for time served, $1,000 fine, 40 hours community service, alcohol and drug evaluation, and recommended treatment, if any, a DUI risk reduction course, and a MADD impact panel.
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you were placed on probation of any kind, you cannot violate any criminal laws or of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you, well, not pleading guilty to a felony, do you understand that you waive any and all defenses by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after trial. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of fleeing and eluding and DUI less safe?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes.
Mr. Oliver has no criminal history to speak of, and with regard to the factual basis, if this case were to proceed to trial, the state would expect to prove beyond a reasonable doubt that on October 13th, 2022, Corporal R. Holman of the Georgia State Patrol initiated a traffic stop after he observed the defendant failing to maintain lane. The defendant, Elijah Oliver, was operating the vehicle at the time. He fled. A pursuit ensued during the chase. Mr. Oliver drove recklessly, weaving through heavy traffic on I-75, traveling at speeds in excess of 140 miles an hour in a 55 mile per hour zone and traveling on the wrong side of the roadway. Ultimately, the GSP trooper utilized a pit maneuver, which is a precision immobilization technique maneuver used to disable the vehicle. Once in custody, Corporal Holman observed that Mr. Oliver had bloodshot and watery eyes, the odor of alcoholic beverage emitted from his person and breath. Mr. Oliver was Mirandized and asked about alcohol consumption. He refused a blood test, and warrants were obtained, and Mr. Oliver was transported to the Fulton County Jail. The plea agreement, as I previously stated, is 30 days. Recommendation is 30 days to serve. Credit for time served. Balance probated. $1,000 fine for count one. 12 months probated to run consecutive to count one. Credit for time served. $1,000 fine. 40 hours community service. Alcohol and drug evaluation and recommended treatment, if any. A DUI risk reduction course and a MAD impact panel. Additionally, I believe Mr. Oliver has a statement that he would like to address to the court.
Go ahead, Mr. Oliver.
Thank you for having me today. I just want to say I apologize for my actions. That's not like me at all. I just want to thank everyone for working with me throughout this process. It wasn't easy. I could promise you that I will never be back in this courtroom again. And I thank everyone that took part in this situation. And I apologize again for my actions because someone could have been severely hurt in that moment in time. I wasn't thinking at the moment, and I just apologize.
Additionally, Your Honor, we do have Mr. Oliver was proactive in attending several courses. He completed a traffic violators impact program, which I have a verification for. He also received he also completed a impact panel, Mothers Against Drunk Driving, which I have a copy of that as well. He has a letter of support from his addiction counselor, Scott Dunbar, and a certificate of completion for the NSC Alive at 25. And then also a driver improvement certificate of completion from the Georgia Department of Driver Services, and a community service hours tracking form. And that just lays out that it was done approximately 33 hours of community service. So Mr. Oliver was very proactive, which is why the state was willing to, do the negotiated plea.
Yes, Judge. Thank you so much. Your Honor, Mr. Oliver is the kind of client that you have that you wish every client could be like. Whenever he came in, he immediately said, "What can I do to correct the situation that I found myself in? Not how can I get out of it, but what is needed out of me in order to make the situation better." So within a couple months of being arrested, he took that defensive driving course. Then a couple days after that, he took the TDIP. A couple days after that, he did the alcohol and drug evaluation with Mr. Dunbar. A couple months after that, he did the MAD impact panel. A month after that, he did the Alive at 25. And then he was doing the community service for the last year or so. I think it's important, Your Honor, to note that Mr. Oliver, prior to his job with the post office that he does now as a mail carrier, and his supervisor does know about this, sent in a letter of support. Prior to that, he was working with special education children, both at Braselton Middle School as well as a school up in New York before he moved down here. And so there's not a lot of times that I really feel like I can honestly say that a client's situation is an anomaly. But with Mr. Oliver, I do truly believe that that is the case. And I think one of the things that speaks to his good character is the fact that he has several people here in his support, if you would stand, if you're here in support of Mr. Oliver. So his mother, as well as his spiritual mother, and some coworkers from the post office, a friend of his are here, and just wanted to show Your Honor that he does have their support and that he will be, thanks so much, y'all can have a seat, and that they will be supporting him to make sure that he does well while he's on probation, Your Honor. So as we discussed up at the bench, I'm requesting that because Mr. Oliver has a very good job with the post office, I don't think he will be actually delivering mail for a while, given that his license is probably going to be suspended for a while. But he still has a job there. Given that fact, I would ask that he be, for the 30 days confinement, placed on an ankle monitoring service so that he can go to and from work, come directly home while he is spending that 30 days, as well as getting the credit for the time he has already served. And then the last thing I would ask Your Honor is, I looked in the traffic enforcement manual that the Department of Driver Services has issued. There is a limited driving permit that can be issued for both the fleeing as well as a first-time DUI. I don't know how the interplay goes with if you do them both at the same time. I'm not sure whether he would be granted that limited driving permit, but if he is able to, I would ask that Your Honor permit him to take the steps to try to get that limited driving permit so that he can continue to carry mail.
It is, you can call, like how we do practice.
The affidavit of first conviction.
I do remember years ago that someone could take a plea under no intended that would help.
Not anymore.
I don't know if that.
I mostly do traffic law, so yeah, I mostly do traffic law. I'm not typically in Superior Court, Your Honor. So I know that he does need an affidavit of first conviction for the DUI. I don't know if you even need one for the fleeing, but
Was that reduced with misdemeanor?
Yes. Yes, Your Honor.
Well, you're reducing the fleeing and attempting to oblige with misdemeanor.
Yeah, yes, Judge.
Anything else?
That's all for me, Your Honor. Thank you so much.
Thanks, Mom, and bonus mom and all the other people. Trying to support him. Hopefully, Mr. Oliver, you downloaded the Uber or Lyft app. Absolutely no reason to get you out of it. I mean, none. None. You don't have some money, I'm sure you call your mom and she'll send you. This is pretty close, I'm saying this right, this is pretty close to me, because I was hit by a drunk driver at 21, almost lost my right leg. Hit me head on. And anyway, someone at hospital, he's like, sorry about that. That was it, sorry about that. And, you know, 140 miles an hour, you could have killed someone. You know, or yourself, and then your mom would be sitting at a funeral home. You know, I don't care if, I mean, obviously not now, but I mean, just use Lyft, stay where you're at, call your mother, call somebody. I mean, there's just no reason for you to do that, and guess what? Blue lights are behind you, kind of a clue to stop. You know, I learned when I was a cop, you never can really outrun the police because they have helicopters. You can't outrun a helicopter, right? I'll accept this plea as freely, voluntarily, and given, and with full knowledge and understanding of everything that you pled to, right? Yeah, if you give me that certificate of first conviction, I will be glad to sign that. But it's probated, right? The rest of this days to serve, probating those 30 days.
I think,
Give him credit for time served and probating those.
yes, Judge. That's, I fully agree.
Yes, Your
with
Honor.
Yeah, okay. And then on your ankle monitor, we'll pay for that, okay? You can leave for court, lawyer, and work, at least for 3 months. Okay? And then I'm thinking let's take it off after that. You feel the straight and narrow, because that way your mom can breathe easy. Knowing that you're not gonna be drinking and driving, okay? Wouldn't have brought your mom and your bonus mom, I don't know, I've been this nice. Right?
that. Yes, ma'am.
All right, best of luck to you, sir.
So just for a point of clarification, he's not going into custody.
No, he's got credit for his time, so he served what?
He served 2 days.
Yeah, 2 days.
So are you commuting that 30 days of time? I'm confused as to what you're doing. What?
I think Mr. Muzingos requested that the ankle monitor and the home.
Right.
Serve as
Right.
the 30 days.
So you're,
And you can make it 90. I think I heard you say 3 months
Yeah.
of the ankle monitor. So maybe do 90 days served on an ankle monitor.
So are we doing?
I gotta be honest.
are you suspending the other days instead of in custody,
I'm sorry?
suspending it? Or making it-
Is count 2 running consecutive to count 1?
It is consecutive.
Yes, yes.
Yeah, so,
It's 12 months plus 30 days?
It's 24 months total.
It's 30 days to serve, 12 months probated to run consecutive with count one. So the 30 days would be the to serve part. So that, but I think you're saying 90 days on ankle monitor.
Okay, so how about 30 days suspended upon his successful completion of the 90 days on the ankle monitor?
No, I just want to know what count 1 is. Are you asking for 12 months? Because the only thing you're saying is 30 days to
Yeah,
serve.
12 months.
So it's 12 months to serve 30 days on the ankle monitor.
Right.
Down is probated.
Right.
Yes, ma'am. You want to give her that? Because it lays it out.
You gotta give me the front end.
The offer form lays it out.
30 days. Okay.
All right, thank you, sir. Best of luck.
Plus
Thank
days,
you, Judge.
30 days.
Once he meets with probation, he's free to go. Thank you, Judge.
Then I'll, and I don't know if you wanted to go and see it.
Yeah. I'll just pop in and see.
Okay.
Your Honor, just to confirm, he's missing the probation, right?
Right.
Okay, it won't be.
It won't be.
Has to reset.
But you'll get them there.
No. So, the information that you provided. All of your documentation. He goes in and misdemeanor for.
Showing everything that they've done.
Sure.
Okay, so 40 hours of unit service, alcohol, recreation, treatment. And maybe you can hit that panel and defensive driving force. And what else?
$1,000 fine.
I have that $1,000 fine, is that on each? Okay. I'm gonna get your floor in a minute, you know.
No, it's okay.
No, my ears got.
So I don't get what, I'll debate. Okay. All right.
Let me see if I can get that. Your next case is Carlos Brandon, so I can get,
I think you put that in.
I was working.
You did.
I'm gonna. I'm trying to work on, you have to just, give the indictments to, Judge Mann.
Mr. Brandon.
No,
Did you tell her? You told her?
You have to see.
Yeah, approach. Yes, ma'am. I just did.
Thank you.
What did you say?
Don't get out there working on my mail. I put it in.
Mhm.
Whenever you're ready to stay.
We're ready, Judge.
Ready to stay?
Okay. Mr. Brandon, can you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court?
That's your right hand. That's your right.
Right hand.
Right hand.
Military right.
Right hand.
Huh?
Okay, all right.
You lead this shit and jump back on.
Okay. All right. So right hand raised. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your true, correct, and legal name.
Carlos Brandon.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
35, 11th grade.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you are charged with the following offenses? Possession of a Schedule II controlled substance, possession of a firearm during the commission of a felony, willful obstruction, tampering with evidence, improper lane change, and possession of a firearm by a convicted felon?
Yes, sir.
Have you reviewed the charges with your attorney, and have they advised you about the potential minimum and maximum sentence for each charge you are pleading to?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss this with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Do you waive a formal reading of the indictment?
We would waive a formal reading of the indictment.
Do you waive any and all defects in the indictment, including
Would
any with
waive.
respect to your name?
We would waive any defects in the indictment for purposes of this plea.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 5 years to serve 6, 5 years to serve 6
5 years to serve 6 years.
6 months.
Oh.
5 years to serve. My apologies, Judge. 5 years to serve 6 months. 5 years consecutive. 12 months probated concurrent. 12 months probated concurrent. 12 months probated concurrent, and then 5 years served 6 months for the possession of firearm by a convicted felon.
Yes, sir.
And that's on indictment 24 SC 000398.
Just to make the record clear, on the 5 years consecutive, you want to say 5 years consecutive probation, you just said 5 years consecutive.
Oh, my apologies. 5 years consecutive probation. On indictment number 24 SC 00097. We've got possession of a Schedule 2 controlled substance. And again, 5 years, serve 6 months. Willful obstruction. We got 6 months to serve. Tampering, 6 months to serve. Concurrent to 24 SC 000398. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, yes, sir.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are not a U.S. citizen, United States citizen, a guilty plea conviction will affect your immigration status and will result in your deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 5 years in prison?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights? The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
All right. How do you plead to the charges of possession of a Schedule II controlled substance, possession of firearm during the commission of a felony, willful obstruction, tampering with evidence, improper lane change, and possession of a firearm by a convicted felon on indictment 24 SC 000398,
Guilty, sir.
and on indictment 24 SC 00097, the charges of possession of Schedule I controlled or Schedule II controlled substance, willful obstruction, and tampering.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
Mr. Brandon's previous criminal history includes a first offender completed without adjudication for possession of marijuana with intent to distribute out of Fulton County Superior Court, docket number or indictment number 09 SC 83775 on November 4th, 2009. We also have felony convictions for possession of cocaine, criminal damage to property, possession of cocaine with intent to distribute, burglary second, and Mr. Brandon has pending cases in Fulton County Superior Court for theft by receiving and aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon.
That's not him, Judge.
I got three fellow on them rounds. You wanna? Yes, Ms. Washington.
That's what there's some, they already said something to you about that and it said some kind of mistake. He was never charged with that.
That ain't me, period.
One's not him, so.
The
Aggravated assault.
aggravated assault and all that, they was just saying, he said, that's not him. They were saying it was an open case against him. He said that he didn't have any other open
Didn't
case.
have any open cases?
No.
Ms. Washington, you got his history?
Yes, Your Honor. There are 28 arrest cycles with multi-state interaction in Alabama and in Georgia. In 2022, there was a felony conviction for possession of a firearm by a convicted felon, and it appears that he is currently serving 7 years on probation for that. In 2019, there was a felony conviction for sale of cocaine. 2010, felony conviction for 3 counts of forgery in the second, possession of a firearm, fleeing, and interference with government property, as well as theft by receiving stolen property. 2010, felony conviction for possession of cocaine, as well as a 2008 felony conviction for possession of cocaine. And nothing further, Your Honor.
Mr. anything?
Judge, we would ask that you go along with the negotiated plea. Mr. Brandon, Judge, has admitted that he has a substance abuse issue as to what led to this conduct in these last 2 indictments. And he, certainly part of this is alcohol and drug evaluation and treatment. He has gone to an evaluation, and I suspect that he is going to be in treatment, Judge.
You got something to say?
Nothing further, Your Honor.
All right, accepting the negotiated and free and voluntary given in the sentence. No drugs, no alcohol, no weapons, no replicas of weapons on both lips. And you did go to drug alcohol evaluation?
Yes, ma'am. RSEP.
Is that?
RSEP.
Okay, They recommended treatment, make sure you follow that treatment, okay?
Yes, ma'am.
All right, thanks. You said 20.
Okay, so what about the 6 months? Sorry. Jail.
He's already, it's, that's,
And he served 112 days, 24 SC 000097, and 120 days and 24 days.
so the 6 months of we've agreed that that would be community time served.
That's fine, Your Honor. Yes.
Best of luck to you, ma'am. Thank you, sir.
Thank you. So he needs to speak with probation. So just have a seat and wait for probation to call him.
Have a seat in the office around.
Thank you, Judge. That's all I had. And may I be excused?
Ma'am, have a good weekend.
All right, y'all too. Y'all too. Thank you.
Judge Manning, Mr. Adams and I have Omar Juarez, I believe that'll be a plea. I have a victim meeting at 1 that I gotta go to. I'll be back at 2. If I could, just hold the plea until I get back.
Absolutely.
Thank you, Judge.
Okay.
Justin Roberts.
Yes.
That's the note.
Mr. Hudson, you're up there. Oh,
That'd be great.
Ask the question.
No. So that if they have any questions,
Yeah, let's get you going.
Can I just mean, I had to release a bunch of people.
Okay.
Okay, the doctor needs to know that I'm.
You can do that.
What is the new work?
He's 46.
Gotcha.
I can't, he said.
How old is he?
No, I mean,
Just because we get these.
if I had an offer, I would be able to take care of the cases today. I can't, I sat down with Mr. Brown for 2 hours on Wednesday. To come in here today,
So.
Number 46 in custody now?
Yes, he is, he's on Riverbend.
Okay. Mr. Roberts goes down. Can you ask who was in there for Riverbend? I'll take you off you.
No, I don't think I can do that.
Equal come, we get
I thought there was a way.
I got his in the grade, so I didn't take that.
Thank you. Thank you.
Okay.
But he haven't.
Okay, hearing this,
Mr. Brown.
or Mr. Brown, but Ms. Taylor, eat something so she can make food real quick.
Is he back here?
Yeah.
Okay. I was saying that, wow, okay. Sorry. So are you ready to bring him out or?
Yeah.
I think she wants.
We're gonna have to give Ms. Sanders a second. So if you
No, I think she wants to watch. Just in case.
I'm gonna go back there.
I don't know. Pray for me.
All right, we're doing number 46, the specific
Which was-
licenses and Judge Carson through in his plate.
I don't have a sleeper.
Robert,
Yeah, I'm going right.
Oh.
Yeah, I don't know.
you don't have a plea worked out?
No.
It's not negotiated and he's
Oh,
ready
okay.
to go.
Gotcha. All right.
We're ready to go.
Good.
I'm about 5, I'm counting down. Yes, sir. Hey.
Anybody got a phone, turn your phone off.
Okay.
Yeah, it's very quick.
I'll go back and do it.
Did you have that?
And confirming.
Oh, no. Oh, okay.
That's very sad.
Oh,
I don't know what he said, what is?
Yes, you do, because Ms. Sanders says, we're sharing our corporate border today with just trying to sell. So she's hopping back and forth. She needs to go eat, but I'm trying to hurry up and take care of stuff.
Okay.
Ms. Hall is looking beautiful.
So are we not taking my pleas today?
We have.
Yes, we're taking every plea today we're gonna
'Cause
take.
I have an appointment at 2:30 that I can't reschedule, and I have my pleas ready since the call of the calendar, so I'm just wondering.
I got you, Ms. Hall. I understand, but it's beyond our control.
Ms. Hall, if it comes to it, you can just let me know the info and I'll take your pleas.
Yeah,
If
I
we have
probably-
to do that.
I probably won't be able to do that because that's me having to give you all the information on all the cases. And when I step away, I have to step away completely.
Okay.
So I've made the court aware and I've been sitting here all morning waiting. So I'll
Me
just
too.
wait.
Me too, Ms. Hall. Could somebody get Mr. Brown?
I'll get him,
Because if
Judge.
I get them, I'll
I'll
like
get him.
go in jail.
We don't want that. Ms. Woods. Mario, we're ready for you.
Didn't I tell him that when he was in here?
did.
So where is he? Robert is on here, he's on there.
And I haven't yet done it.
So Robert could have found, go ahead and say something for me so we make sure we can hear.
Yes, ma'am.
Okay, thank you, sir. Well, this is position 46, the standard, underscore FP 0022022. All right, go ahead, what's the state, Brown?
All right. Mr. Gotel, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your true, correct, and legal name.
Justin Michael Roberts Cattell.
Put your hand down, sir.
You spell his middle name, especially.
Can you,
Can you spell your middle name?
Micheal.
Okay.
are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
32 years old, a GD.
I'm sorry, can you speak up and enunciate? We have a court reporter who's trying to take down everything you're saying.
32 years of age, GD.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you are charged with the following offenses? Aggravated assault, possession of a firearm by a convicted felon, possession of a firearm during the commission of a felony.
Yes, sir.
Have you reviewed these charges with your attorney, and have they advised you about the potential minimum and maximum sentence for each charge you are pleading to?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss this with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Do you waive a formal reading of the indictment?
Yes, we do.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, sir. Yes.
Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state would still recommend a sentence
Yes, sir.
of 15 years to serve? Are you aware of the state's prior offers?
Your Honor, I was going to address the state's offer. Mr. Rao actually made the offer, who's the actual boss. That was not his offer, but I didn't get a chance to talk to Mr. Brown about it. So that's why it's non-negotiated, because we're so close. And Judge, I'll just wait till it's our turn. But for the purposes of this plea, Mr. Gotel, that's their offer, okay? He had actually, Mr. Rao had actually offered 5 years to serve, Judge. That's his actual offer when we was in court last time. And he told me that last week when we came to see Ms. Woods, that he was offering 5 years to serve to Mr. Gotel.
You know, I don't have that in writing, but you know, we go off the representation of counsel. But for purposes of this plea, Are you aware of the state's or are you aware of the state's prior offers, and have you discussed their offer with your attorney?
Yes, sir.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, sir.
Do you understand that if you enter a non-negotiated plea, you do have a right to withdraw your plea once the sentence has been announced?
Yes, sir.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 5 years in prison?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, sir.
the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Hold on, Mr. Gotel. The answer to that, Judge, when we were speaking to Mr. Rao, is going to be guilty under North Carolina versus Alfred.
Gonna be alpha plea, okay.
Okay.
So Mr. Gotel say guilty under Alfred.
Guilty under Alpha.
Okay.
With that saying, Mr. Brown, you asked him, are you pleading guilty because it's in your best interest? Because the jury likely will find you guilty if you were to proceed to trial. That's the North Carolina versus Alfred statute that you
Right.
usually repeat to
Yep.
the defendant after that.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, sir.
How do you plead to the charges of aggravated assault under OCGA 16-521, possession of a firearm during the commission of a felony under OCGA 1611-106, possession of a firearm by a convicted felon under OCGA 1611-131B, and use of a firearm by a convicted felon during the commission of a crime under 1611-133?
I'll ask my attorney to speak for me.
You just pled guilty.
Can you repeat what you just said?
Can you say guilty under Alfred? He asking how you plead. You saying you're guilty, but you don't agree with the facts. So will you repeat and say guilty under Alfred like we discussed?
Guilty under Alfred.
Okay. And that's under indictment number 24 SC 002022. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
All right. So Mr. Gotel's GCIC reveals that he has felony convictions under 11 SC 98726, possession of marijuana with intent to distribute, Fulton County Superior Court, February 1st, 2012. We have an obstruction misdemeanor. We have a felony conviction under indictment number 13 SC 120811, possession with intent to distribute cocaine, and that's out of Fulton County. We have another aggravated assault under indictment number 19 SC 172577, Fulton County Superior Court 4921. Use of a firearm by a felon, possession of firearm during the commission of a felony, and then a possession of a firearm by a convicted felon. We have possession of a Schedule 2 controlled substance out of Cobb County Superior Court, and that's May 30th of 2023. All right. If this case were to proceed to trial, the state expects to prove beyond a reasonable doubt that on June 5th, 2022, officers of the Atlanta Police Department responded to 2456 Martin Luther King Jr. Drive in Fulton County concerning an armed and dangerous person making threats to others with a firearm. Upon arrival, they met with a witness, Cedric Strozier, who advised that his nephew, not by blood, had been taking drugs and was outside 50 Peyton Road carrying a rifle and threatening people. Police relocated and were directed to apartment 6, where they encountered the defendant. He surrendered and was detained. Police then learned that a silver Toyota in the parking lot was in the possession of the defendant. Officers looked into the car and saw the firearm. They then spoke to another witness who advised that she drove the vehicle to the location, but the defendant told her to keep running. She also advised that the defendant had a firearm. It was then recovered from the vehicle. Police then spoke with the victim, who advised that he had walked past the defendant in the parking lot on the way to his car. They exchanged words about the defendant's lack of respect for others in the area. The defendant pulled his weapon, a rifle, and pointed it at him while threatening him. Police arrested the defendant on scene. That's it for the state, Your Honor.
Your Honor, Mr. Brown, thank you for the rendition of facts. Judge, I just want to highlight the facts. Mr. Brown actually corrected the facts as we know them. That is accurate, Judge. My client did not get caught with a weapon. However, Judge, my client was on drugs at the time. That's the reason why he has that record that he has. The Cobb County conviction, Judge, was represented by Mr. Andrew Schwall'S, who also used to be a prosecutor in Fulton like me. We all used to work together. So actually came from Cobb County to Fulton, and he had two judges, Judge. He had Judge Frazier and Judge Drake. So Judge Frazier revoked 2 years. Like, we was going to court. This case been open, Judge, for a while. So Judge Frazier had revoked 2 years for this case, and he told us, since y'all going to Schwall'S, y'all can go ahead and run everything together. However, this case handled first, and then me and the previous prosecutors had an agreement to run the 2 years concurrent with this case already. However, Judge, my client got revoked first on this case, and the state indicted this case second. You can see the 24 SC case number, because this incident actually happened, I believe, in 2022 or 2023. So That's where the disconnect comes, Judge. Also, my client, he is, and the thing is, Judge, I had a prior prosecutor who actually was going to run it concurrent. Then Mr. Rao took over. He got promoted and he became the supervisor. So we've been negotiating. His initial offer was 15 years to serve, Judge, and that's accurate. Then he reduced it and said, well, I'll give him 5. But then I told him, I said, well, Justin been in jail since June 3rd, 2022, and Justin been doing so good. So, Judge, we was going to ask, and he has a tentative parole date and a parole eligibility date. So the Department of Corrections is letting Justin put him up for parole in 2 years. And Mr. Gotel would like to tell the court what's going on with him. But Judge, my client is expecting to go to jail today. He's not expecting to get 15 years or even 5, but somewhere in the interim between that 2, 3, or 4 scale, Judge, he's already been revoked, and Judge Drake actually corrected the sentence and only revoked him for a year. However, the Department of Corrections still got him down for 2 years, and he got to do the 2 years. So no matter what, I'm okay with it, Judge, because his paperwork never got corrected, so he's doing 2 years no matter what. I was telling Justin that be expecting that between the interim, he might have to do another year. So even if he gets 3 years to serve, Judge, Mr. Gotel will be happy with that. Judge, he's not a recidivist, and no one got injured. And the alleged victim sent the waiver to the DA's office, telling them he didn't want to prosecute his nephew. However, because Justin stayed with him from time to time, and he'd be with Justin's grandmother from time to time. However, I think that it's best that Justin do some time in jail because Justin needed it, Judge. He was addicted to drugs. He since then motivation for change, reentry, and he did already complete his GED, but he's working through an early release program through the jail, through the Department of Corrections. And Yana, Mr. Gotel would like to tell you when his expected release date. But Judge, I expect that Mr. Gotel will get some more time on top of that. But that's my rendition, Judge, and I just wanted to let you know that my client since then has got all the drug treatment in the Department of Corrections. So, Judge, I believe that this will be a fair resolution. Anything that's run concurrent that's under 5 years, between 2 and 4 years, or 2 and 3 years will be more appropriate, given that this case is supposed to have been resolved in 2022 with his revocation already. Thank you.
Mr. Hudson, what was your breakdown? Because there's 4 charges.
You know what? Gotham said that he wasn't really too worried about the aggravated assault. So he was like, I'll just give him 5 years for everything. And so I told Gotham that he was getting ready to parole out. So Gotham like, well, he'll leave it to the judge. So initially, the initial prosecutor was giving Mr. Gotel 18 months. But due to changes in scheduling and a lack of communication and getting him on the calendar, and also hadn't talked to the alleged victims and witnesses, their recommendation changed. But it's okay because Mr. Gotel was expecting that. So, Judge, I'm asking for 5 served 2 or 5 served 3, but nothing more than 3, Judge, because he's already under confinement. And I told Justin he might have to do another year or maybe another 18 months. His mother is, she's elderly and she's ill, and she's expressed to me her love for her son. And also, finally, Judge, he wants to get out and get back to work. One thing about Justin, he was working, Judge, before he started doing all this stupid crap, before he got addicted to drugs. So he's been addressing his drug problem since he's been in jail. So, Judge, I believe that if you give him a second chance and not let him get out, Judge, no time served, he doesn't deserve that. But he doesn't deserve the 5 years, and he doesn't deserve that max.
I just want to correct the record. I think Mr. Hudson represented that Mr. Gotel was not a recidivist, but I do have indication he is a recidivist with at least 3 felony convictions, which I did state previously. 1 for burglary under indictment number 11 SC 104942 on February 1st, 2012 in Fulton County Superior Court. We also have indictment number 11 SC 98726, possession of marijuana, Fulton County, on February 1st, 2012, and then 13 SC 120811, possession of cocaine with intent to distribute, Fulton County Superior Court, November 9th, 2007.
And let me add this, Judge. That's true, Mr. Gotel is a recidivist under both A and C. But our agreement was, since they not presenting any certifies, he was not gonna get sentenced as a recidivist, but he was gonna get sentenced and he was going back to prison, or he's gonna stay in prison. So that's what we had discussed, Judge. And this case been around for about 6 months that we've been trying to negotiate it. And Judge, luckily, you was already here the first time, Judge, when you filled in for Judge Schwall. So you remember, Judge. Okay.
I have Ernest Norris as the victim. Is he related to Ernest Norris?
You said what now?
Ernest Norris is the victim.
Yes. That's like his uncle. They not related by blood, but he actually raised Justin.
Okay. All right. All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no replicated weapons. No further violent contact with Ernest Norris. Now, I know that Mr. Brown said while you're on probation, you can't have a gun. Sir, you can't have a gun or be around a gun for the rest of your life. You're a convicted felon. It's not just while you're on probation, right? So.
Also, Your Honor, I just wanted to point out, my recommendation was 5 serve 3, Judge, in case I didn't make it clear. But that's why we're going non-negotiated.
All right. So I'll give you 5 years on each one, run concurrent and 3 to serve.
Thank you, Judge. Judge, can he get the credit from June 3rd, 2024? We appreciate that.
All right, you say.
You need to figure it out. Do you want that balance judge to be suspended?
I don't know about.
Because is he already on active probation, Mr. Hudson?
Yes, he's still on probation with Judge Frazier and Judge Drake. But either way, he lives in Fulton County, Judge, so he's gonna be reporting.
All right, we'll get it. We'll get it figured out.
So count 1 would be 5 years to serve, 3 years balance suspended. Count 2 would be 5 years concurrent suspended. Count 3 would be 5 years consecutive suspended with count 1. And count 4 would be 5 years concurrent suspended.
Yeah.
Was it 5 years to serve, Judge, or 3 years? 5 to serve 3. Which one is it?
Wait a minute, hold on.
3 years serve, because you know.
You wanted to serve 3, right?
Right.
5 years to serve 3.
Right.
I have 5 years to serve 3, the balance of those 2 years is suspended. Count 2, possession of a firearm by a convicted felon, I have 5 years suspended, but to run concurrent. Count 3, possession of firearm during the commission was always consecutive to the felony, so that would be 5 years suspended consecutive to count 1. Count 4 should be 5 years suspended.
Yeah.
With count.
Thank you, Your Honor.
All right. Thank you, Mr. Gotel.
And thank you, Mr. Brown. And Judge, my client been in jail since June 3rd, 2024. So can they reflect on the sentence sheet?
Yes, we can, right?
Thank you, Your Honor.
All right. Good to see you, Mr. Hudson. Thank you.
Thank you, Judge. And thank you once again, Ms. Woods. I appreciate you too as well. Bye-bye.
You have 1 person in custody, Mr. Stevens, that's.
Go ahead, Candy.
Go ahead, Ms. Sanders.
She should have been back till 1:20, so let's go. Keep going. Okay. All right, we're gonna stand down for about just 10 minutes.
I gotta, is it, what we doing, Mr. Stevens?
Everything is reset per Mr. Rao. So I was gonna put it on the record. All my cases with Mr. Brown are reset per Mr. Rao.
Where is he?
He left and I asked him to stay. I asked him to stay because I knew that this was gonna be an issue.
It's an issue.
But everyone, you know,
We have.
It is,
have
and
Mrs.
I'm gonna talk to
Mrs.
y'all in the back,
Oh,
because we
we don't
got
have a
too many people out here in the front.
can everyone take just a break?
Your Honor, can go till be dismissed? Let me get her, see if I can get her.
We might have lost Ms. Thompson.
She went to go change her appointment. I didn't know that it was a DB, case, sorry. Let me see if I can. Grab her. Like, sir.
What? Is, yeah, get a container.
I hope he does. You want to know the other few cases so you can know what to ask for? That's why he's not just.
Mr. Spratling is here. We don't have Ms. Hall.
Ms. Hall, appointment. And she'll be
And you have to go to
back.
work.
She has 6 weeks.
Okay, okay.
It's a little bit different.
No.
Yeah.
Not gonna be.
And I can't keep telling him the same thing. That's exactly what I can't.
I'm trying to get Ms. Hall, so I mean.
Is it a negotiated plea?
It is, but if not, I guess I would ask, can we reset it so that he can pick his kid up?
Trying to get on. And she just, I didn't know the UB case.
Yeah, I just.
We also, oh, sorry.
We can do probation. I'm ready.
I'll have the number, please.
Okay, well, let me do that.
College Park.
All right. No, he's jumping. All right.
So this is number 37.
Sign there, count to reduce to the pointing a weapon. And you sign it. And this is your position.
You said I got a carb hold. You said carb hold. Get a hold for carbs.
Oh, no, that's not you.
Oh, I was gonna say, ain't no way.
That was before. That was the old, that's the old note.
So just let us know when you're ready.
Like you said,
Yeah, she jumped on. Okay.
Trying to find what position this is.
37.
Oh, you found, I got 35.
I'm saying, when did they had all that?
Oh, that's what they indicted you on. Yeah.
Ready, Ms. Hall?
I'm ready.
All right, it's number 37, Preston Spratling, 24 SC 005132. Go ahead, Ms. Hall.
Mrs. Spradlin, can you please raise your right hand? Do you swear or affirm the testimony you should give in a matter currently before a court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Preston Spratling.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been today?
No, ma'am.
How old are you and how far have you gone to school?
31. I got my GD in prison.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with aggravated assault, possession of a firearm, possession of a firearm during the commission of a felony being reduced by the state to pointing a pistol at another, battery, family violence, and possession of a firearm by a convicted felon?
Yes, ma'am.
Do you understand you have the right to plead either guilty or not guilty to those charges? And if you plead you're not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Yes.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, for the purposes of the plea.
Mr. Spradlin, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
For aggravated assault, family violence is 3 to 20 years to serve. For the pointing the pistol at another and the battery, those are both misdemeanors. The maximum is 12 months to serve. And for possession of a firearm by a convicted felon, the minimum maximum is 1 to 10 years to serve. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea? I'm sorry, do you
Yes, ma'am.
understand the negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years probation. Special conditions, you have no contact with the victim in this case and complete the family violence intervention program. The court does not have to accept that recommendation. The court can sentence you on the maximum of each charge and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
In indictment number 24SC 005132, how do you plead to the charges of aggravated assault, family violence, pointing a pistol at another, battery, and possession of a firearm by a convicted felon?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the constitutionality of this guilty plea?
Yes, ma'am.
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on September 25th, 2023, officers responded to 741 Morrogo, Drive, that's Atlanta, Georgia, Fulton County. When they got to that location, they spoke with the victim in this case, and first name is Clydraria, last name Wilburn. They spoke with Ms. Wilburn. They spoke with her, and she said that she had gotten into an altercation with her ex-boyfriend, the defendant, who was also the father of her unborn child. At some point, the victim was going into her apartment. Defendant, came behind her and, came into her apartment. There was a maintenance man at this apartment doing, some maintenance work in her kitchen when this occurred. The defendant ended up grabbing the victim. She was 4 months pregnant at the time, and drug her across the floor. He also choked her. He struck her in the face, with a handgun that he had. And when officers arrived, they did see a mark over the victim's eye, leaving bruises there. There was a maintenance man who officers spoke with. He did not want to be involved in this case, so we did not have his name, but he did speak with officers about what transpired when the defendant came and attacked the victim. We have spoken with the victim, in this case, Your Honor, and she doesn't want any contact, any violent contact with the defendant, and she doesn't want any communication with the defendant. So that's why we did no contact with Ms. Woodburn as a condition of his probation. That is all from the state.
Right, I think we're-
Just from the defense, Ms. Hall, do I have permission to sign your name on the indictment? And regarding defense, I would just ask that you follow the negotiated recommendation. We obviously disagree with some of the facts as stated, but he does admit that the altercation ensued, and so that's why he's entering this guilty plea.
And yes, the court has my permission to sign the indictment.
Anything else from the state?
Nothing further from the state.
All right, I'll accept this plea as voluntarily informed and taken down. No further contact with the victim. Daria Wilburn, no drugs, no alcohol, no weapons, no replicas of weapons. She must complete that family violence intervention program. It's like a 24 or 26 week class, okay? And then submit proof to probation that you did that. So probation.
1 second.
Ma'am,
I'm sorry.
She did 3 years on count 1, 12 months probation on count 2, 12 on count 3. So she did.
Yes, Your Honor.
Yes, Your Honor. And the same for count 4, the possession by would be the 3 years probation as well.
Anything else?
I know, Your Honor, and those are all concurrent, I believe.
Yeah. Right, okay. I guess probably need.
You just have to talk to her real quick. When you're off there. Thanks. Not Ms. Hall. I don't think everything else from Ms. Hall. We have other.
So how long do we have to?
Well, I was trying to reschedule it, remember? So I just got off the phone when y'all made me come back to court, so I don't know. Like I had to leave at 2:30. And so I was trying to reschedule it, but I had to get off the phone to come and take this plea, so what do y'all want me to do?
We can discuss Mr. Baines real quick if you want to log off or you want to be here for Mr. Baines.
Yeah, we can do whatever y'all want to do. I'm here, ready.
Okay, now we can get.
We have probation stuff to do.
And then we got probation, there's one thing I need to here and just, we do have to give this all, you know, the same steps. And let me go find Mr. Nzingo and get this file.
Okay, so are we gonna do Baines and then y'all gonna do probation stuff and then we're gonna finish my pleas or what?
Yes, ma'am, that'll be fine.
Okay.
Your Honor, in regard to Mr. Baines, he's online. I was just getting there.
Do you want to?
Yeah.
I need to know what it is.
Position 48.
Okay.
And we'll take a step down, y'all, and y'all step out and talk.
Why you just can't?
Yes. Christopher Baines, he's online, Your Honor. His current charges are aggravated assault and aggravated battery. He was offered the adult diversion program sometime back. Since that time, Mr. Baines has been removed from the program. And he feels at this time, his request is to ask the court to dismiss the case. I attempted to explain there's an offer that's been made, a misdemeanor offer that's been made. I did explain that to Mr. Baines, as well as the judicial process, which would require at this point, if he didn't want to enter or accept a plea, to the misdemeanor and enter a plea of guilty, that the next steps would be trial. However, he believes that the court should dismiss the case. And so that's just a little bit of background, and then I'm gonna just turn it over to Mr. Baines to add anything in addition that he'd like.
Good afternoon, Your Honor.
Raise your hand.
He's my kid.
Firm testimony about to give is the truth. Raise your hand. You swear firm testimony about to give is the truth, whole truth, nothing but the truth.
Yes.
All right, let's go ahead. You speak up a little bit, because the court has to take it now.
Okay, Your Honor, the prosecution had gave me a deal into which I was basically required to complete a certain amount of steps in order to basically have the cases dismissed as far as the deferral program and pretrial. Now, given that to understand, I completed everything I could complete on my end. The issue came about when a part of the deal was for me to contact the prosecutor within 48 hours of signing the deal, which I did immediately. I did not get a response. Once I contacted the prosecutor, she told me that I had to go back and talk to my attorney. My attorney told me I had to go back to her, so they gave me a runaround. Now, I completed everything else as far as the community service, staying. I actually, because of this case, I moved 2,000 miles away from the alleged victim in order to keep away from any problems. I have been working hard, basically trying to get me a job and trying to basically become a professional. For 4 months, I have been contacting the DA and my attorney in order for them basically to get me into the classes. I did not get any response. I didn't get no enrollment or for none of that. And an incentive of the deal is that if I complete those steps within 6 months, I'll be allowed to basically get the case dismissed early. It got to the 4th month, basically 4th month and 5 days, and I still didn't get no response. Now, during that time, I had experienced homelessness, I experienced starvation, and I experienced the death of my grandmother a week prior to that. When I emailed her the letter, I had not eaten in 3 days. So I was under extreme duress. And I'm steady contacting everybody just to try to see if I can get this last little step of the process done. By the time it was the 4th month, one of those courses takes 10 weeks, which is 2.5 months, which actually would have eliminated me from the 6 month incentive that I was basically trying to achieve. And with that situation, behold, I contacted both of the attorney and the DA and let them know my displeasure for them basically dragging their feet and basically giving me the runaround the whole time when I'm adamantly trying to get this job done. And because apparently I offended them, which I showed the email, I was professional the whole time. I just voiced my displeasure for the just lack of cooperation. The DA deemed me basically basically deemed me not basically a good candidate for the program. And then she said basically you got to take it back to the judge. Now, me personally, I felt like I was given a faulty deal, and I feel like that for this situation, a special performance order needs to be enacted. Because I can in order to basically get this done. I have not contacted the witnesses. I actually currently I just accepted an offer from Northwestern Mutual brokerage firm to become a finance manager. And on February 19th, I passed the license and disability exam on my first try, which not too many people even passed on the first try. But I've been gainfully basically the best I can from my efforts in order to get this done. And I didn't get no cooperation or help from the other side. And which really upset me that I'm still going through this process I'm still living in my car. And I'm basically trying to get employed so I can basically get on my feet. I had nothing to do with this situation. Well, I had no fault in this situation because I kept contacting both sides in order for them to please help me get this done. And nobody wanted to help me. And I felt like that was a faulty deal, and I felt like it was an unconscionable deal. And I felt like the court should at least hear me on that and understand where I'm coming from, and feel like the DA should honor their portion of the deal and basically dismiss both charges.
That's all. That's all.
Yes, Your Honor. I have no idea what the defendant is referring to when he says that he's spoken with me multiple times. I haven't had one conversation with this defendant, even when I gave the offer to his attorney when we sent him into diversion. So I'm not sure who he spoke with at my office, but he certainly did not speak with me. Your Honor, just to give you some background, the defendant was charged with aggravated assault and aggravated battery. Because there was a victim in this case that did not want to see him go to jail, we worked back and forth, me and defense counsel, and we finally came up to this offer of him doing a diversion program for 6 months. I don't know why he failed to do that. I listened to what he said. It sounded like he said he didn't do community service. He was trying to contact us and all other type of things. But there is a list of things he should have done. And if those were completed, when I got notification of that, as you know, Your Honor, I would have dismissed the case. I have not to this day gotten any notification that he's completed anything. Maybe Ms. Carter can fill me in on if he had issues entering the program.
Yeah.
But as far as you, Mr. Baines, if you can give me a moment, as far as I know, Your Honor, he was entered into the program. I don't know, or at least I'm not aware of any issues that he was having. If that's the case, we could have dealt with that. But I have spoken with his attorney multiple times. I even, because he got kicked out, offered a misdemeanor instead. And now he just wants a dismissal. And so that's not something we're inclined to do. We do believe that he did commit the crimes that he committed. We didn't have to give him diversion. I do not have to dismiss the cases or reduce them to a misdemeanor. So at this point, Your Honor, if he doesn't want to work the case out, the case can move forward to trial, and the state will say we're ready.
Your Honor,
And just to clarify, he was given the adult diversion program. Part of entering the adult diversion program is that you attend an orientation. And at that orientation, they explain some classes that they offer, as well as explain where you can and can't do the community service, things like that. When he entered the program, initially, we were waiting for the judicial hold to go through. That judicial hold went through for him to start the program. At that time, it was during the cyber attack, so there was nothing going out. So he was contacting me. I was then contacting the state to say, hey, he still needs an orientation date. Let me know when you can get an orientation date. This kind of went back and forth. Every time he contacted me, I would contact them. He also had, it's Ramona Toole, I think she's a deputy a deputy ADA or DA, I'm not sure. But he also had her contact information. He sent an email to myself and them that they didn't find to be appropriate. And at that time, they deemed that we're not going to accept you into the program. This is kind of a gift. This is, that you are allowed to enter the program. And based on this email that you sent, we're going to remove you from the program. So he was not, at that point, never able to finish the program because he wasn't able to attend the orientation or the classes that they offer. So while he may have done some community service, he did not complete the entire program.
Your Honor, I'd like to speak. I have email documentation and timestamp from the addresses I was given to email these ladies. I can send it to you right now. I contact both these ladies. I have documentation showing that I did complete the community service. I completed basically the supervision. I completed everything else except the part that was required. I was never given the opportunity to enroll in those classes, even though I contacted her. And let me say this, the security hack happened on January 27th. I signed the deal on January 24th. That was 24 hours. The expiration of that 48-hour time span was 24 hours before the January 27th. So that means the 25th and 26th, I did not get any information. I can submit the emails when I contacted whoever's Anthony Hall.
Right.
When I contacted them, I have.
Wait, put your mute. I'm gonna put your mute because I'm gonna talk. I'm not dismissing the case, so you can continue to communicate with Ms. Carter. She can continue to communicate with the state, but I guess you're gonna put this ready for trial, Ms. Carter.
If that's what Mr. Baines wants, if he wants, if we're going to formally reject the misdemeanor offer, our next step would be trial. The only thing I would ask of the court, if we could possibly specially set that date, so Mr. Trial knows to avail himself to the state of Georgia.
Your Honor, I have documentation that I did my part. Is what I'm saying. I have documentation.
I'm not going to dismiss the charge.
No, I said, can they have you honor that? How you? I just need to understand as far as how can you just offer somebody a deal and not do your part, and I did everything to complete my part.
All right, Mr. Banks, put you on mute again. I'm not going to dismiss the charge. I have a full room here of people, well, can we special set it for next, you have to give him notice, or we have enough time to give him notice for, in that trial calendar? And you can continue to talk with Ms. Carter, and, she can continue to talk to Ms. Hall. If that's possible. And then you don't get paid certain for this.
How much time is it? I don't wanna say the railroad.
How long will it take you to get here, Mr. Baines?
Take yourself off mute, Mr. Banks, just answer how long it will take you to get here.
I don't have a specific time span because basically, because of this process, I've been
And
getting
Mr.
denied.
Banks, Mr. Banks.
It's just
Wherever you're at, like a 3-hour drive, a 2-hour drive, a 4-hour drive. It's not, you
Your
don't
Honor,
know.
Your Honor, I live in California. It's a 32-hour drive.
Okay, well, you either plane or 32 hours. You gotta fly or you gotta drive.
I can't call it right now because I don't have a vehicle that can drive 32 hours.
I guess you'll fly, okay.
So do you need 30 days to avail yourself for a trial date? Because your next court date, we will be going to trial.
I'm saying as far as apparently it's not gonna get dismissed. Is there some way we can still work out a deal?
You need
And if
30
not,
days.
Yes, we can.
We can still
Me and
work
your
out.
attorney will speak about that and we'll talk about that. Yes, we can. Yes.
Yeah,
There's-
I can, just, you can mute for now, Mr. Baines, and I'll give you a call. And I think that we have it's just a 12-month probated sentence and I think an anger management course. Is that acceptable, Ms. Hall?
Yes.
Okay, I'm gonna go over the plea colloquy with him real quick and then we can come back on and we can enter the plea.
Okay.
No. I'm about to get off. So y'all
Oh,
just let me know
okay.
what you're gonna do.
No, she's gonna get back on later.
You're gonna get back on later?
She's got
Yeah.
things to do.
I'll call him and then by the time you get back, we'll be ready.
Okay.
Okay. Thank you, Ms. Hall.
Thank you, Ms. Hall. All right, now, what else?
You're welcome.
You ready for the month?
Yeah.
Okay.
DeMonte McNabb,
You need to hang back.
he's position number 5 on the trial calendar,
He's the
I believe. Yeah, the co-defendant.
What?
He only had one case. Well, he has 2 listed there, but one has been dismissed. One is a re-indictment of it. So it's case 2147. I think that's number 5. Number 8. Yeah, McNabb. Oh, okay. Sorry, I didn't print that one. I'm sorry. It's been that kind of day.
782.
It is 2147.
2147.
Is this negotiated?
It may or may not, but are you in plea or just hearing? Oh.
Sorry, Ms. Woods?
Is this negotiated or not?
He's rejecting the offer as far as I know from his attorney, so we're just putting it on the record. His attorney wanted us to put it on the record.
Okay.
I
Well,
know.
hang on one second for me.
Feel like it's been 2
I'm
minutes.
gonna call
now.
Mr. Baines real quick.
Hmm?
And I'm
Should I negotiate or do I take?
No, I mean, it would be, that would be it, the 30 10. We can
I'm
ask
gonna
for
look.
less time.
My head's pounding though, so I'm like,
Yeah, go get you
Can
some.
you ask me?
I mean, I didn't
what-
eat, so I can't take town, I'll throw
No,
up.
it's, you either have to. Your Honor, in this case, what we would like to do is, we want, it's essentially a non-negotiated plea. We want to, I wanted to have the state put their offer on the record. I was going to make a request for less time than that, but essentially he understands that I want him to understand what the offer is, make a request to the court for something different, and let the court tell him if you would be willing to do it or not.
So, Your Honor, on case number 24SC002147, State versus DeMonte McNabb, the maximum exposure on the indictment that Mr. McNabb is facing is 2 life sentences plus 195 years. The state is offering to null pros all counts with the exception of count 1, participation in criminal street gang activity, and count 17, attempted armed robbery. For count 1, the recommended sentence is 10 years to serve in confinement. Count 17, 30 years to serve 10 years in confinement with the balance probated with the following terms of probation. Statutory gang conditions, namely no further criminal street gang activity and no contact with any associate or member of a criminal street gang. No contact with the victims alleged in the indictment, the victim's family members, co-defendants, and the incident location. No guns or replicas, a Fourth Amendment waiver, and no drugs or alcohol. And we are not objecting to an offered plea in this case if he wanted to do that.
And Your Honor, in this case, I believe you sentenced the co-defendant earlier. Mr. McNabb, and the state has not filed any recidivist notice in this case, so he is not a recidivist as far as this plea goes. Mr. McNabb is there was a group of people, I think 5 in total. Mr. McNabb was the least culpable in this situation. He was driving the vehicle. He ran into some friends from his neighborhood. He agreed to drive them around that day in exchange for payment. At one of the stops, 3 gentlemen who were in the rear of his car are much younger than him. They are one of them was the brother of the prior co-defendant, Mr. McDowell. Those 3 gentlemen went to buy marijuana and decided they were going to commit a robbery, and during that robbery, someone was murdered. Mr. McNabb didn't have any idea what was happening that day from our perspective. He was just the vehicle. And so I did tell him, I mean, when we've gone over his discovery, I told him what he did wrong was when he saw these gentlemen get in his car, he should have said, hey, you guys can't get in here. I know that you're, not people I should be hanging out with, shouldn't be giving you a ride, but he did. And so here he is. He has not been in trouble for 10 years. He was working. His mother's here. He can live with her once he gets out. And so what I'm asking the court to do is, I thought a more reasonable sentence would be I know that there is a requirement of the 10 on the gang charge, but I'm asking the court to give him a shorter period of probation or no probation following that. And if the court would consider giving him a reduced sentence to serve of 5 years as opposed to the 10, I think given what his actual activity was in this case, which essentially was just driving, according to everyone involved, he never got out the car, he never had a weapon, he never went in the house, he didn't shoot anybody, he didn't hurt anybody, he just drove. And so we're asking the court not to give him the 30 years with 10 to serve. He has been in for 460 days at this point. We would also ask for credit for that time, obviously, and we would want to do it as an Alfred plea.
So, Judge, the last conversation I had with Mr. Norman, he told me they were gonna reject the plea. So I neglected to give this court this defendant's criminal history, which.
Washington on here, can we get it?
Sorry?
I got it.
Oh, yeah, you can get it from her. That's fine.
Yes, there are 8 arrest cycles. I did not see any felony convictions that were listed on the GCIC. There was a 2014 misdemeanor conviction for theft by taking, and nothing further.
He does have convictions, Your Honor. They're just not listed on the GCIC. In 2013, he was convicted of 2 counts of robbery and 2 counts of aggravated assault with intent to rob. Also, it shows here possession of a firearm during a felony and obstruction of law enforcement. And it looks like he pled guilty to that case in 2015. Also in
Is it juvenile with that phone?
I don't believe so. It was in Superior Court. There's an SC number. So if he was, he would have been charged. Maybe it was an armed robbery reduced to robbery. Theft, a misdemeanor in Douglas State Court in 2014. In 2019, he was arrested for false imprisonment, battery, That was in Clayton County Superior Court. There's a 2020 CR number, so that means it was indicted in Clayton County, but it's still showing as pending on the GCIC. And it looks like he was convicted of a battery in 2021 in the Cab State Court. Judge, Mr. McNabb, it is true that he was the getaway driver in this case. It's very hard to believe that he did not know what was going to go down in this case when at least three armed men got into his car, one of whom was armed with a rifle. And then they got out of the car and some are running back. So that is very difficult to believe that he was just an innocent driver. Given his history, granted, the recommendation for him is lesser than the last two because we do take into consideration that he did not get out of the car. But the theory of this case for Mr. McNabb is conspiracy liability and parties to the crime. But for him driving them to that location, they would have not gotten there. And it's that simple, Your Honor. So if he wants to go ahead and enter a plea, then I can go through the colloquy, but at this point, I'm not even sure what he's doing.
Well, do you want to plead with you? I really want to ask me where she wants you to do it. It's an unusual request, Your Honor, but may the defendant have a moment to talk to his mother who is in the audience? Sorry. If we could just give it 1 minute and then come back.
Because there's a copy that he has to get where he served and knows that, I don't know if it's that. See, we're going to come in. Go up there and help her now. You got us doing stuff. We ain't done it.
We got probation, yeah, 30 to 12. All three. Yeah, joint. I mean, I didn't handle it, but that was just.
We have some probation revocation. Can we take care of Mr. Hammond because he's driving the officer's crazy?
We can see. Okay. Everything, we're gonna handle whenever.
Well, I'm asking, can I bring him now? Because he's called.
Handle our brief revocations. Yes. We got somebody that is fucking. Yes.
Oh.
I don't know. Mr. Hammond. Yeah. Which one is it, April?
What do you have to do?
Which one is it? On the revocation calendar, this, I think it's just. They're all different, 3 or 4. Right off the ground. And Hammond is we deal with 4. And then we get rid of those inmates and everything like that. Okay, and then I need to meet with Mr. Adams. Okay. And then I think they'll take most care of all that, and while we're waiting on. Oh, yeah, hang on. This is Mr. Hammond.
This is Mr. Hammond. He is
Revocation.
revocation calendar, position number 4. Oh, sorry.
Thank you. On the revocation calendar. Yes. Officer Brown.
Okay, Your Honor.
The docket for revocation is 21 SC 177666. The alleged violations states that the defendant was arrested on 11/5/24 by APD for possession of firearm by convicted felon, willful obstruction, and marijuana possession less than 1 ounce. The defendant was arrested for murder on or about 6/17/2024 in Fulton County. Additional charges for the 11/5/24 arrest. States on defendant's booking is on unlawful for persons employed by, associated with criminal street gang to conduct participation in criminal, and unlawful for persons who commit offense with intent to obtain, earn, membership, maintain, increase status. The second violation is failure to report. The defendant has failed to call in to the CRU monthly as required, and failure to pay. The defendant has not made any payments. The balance of $585 is outstanding. Failure to complete community service. The defendant has not completed any community service hours. I did agree to a reduction from my original offer, for my original recommendation, and I have agreed to 12 months to serve and suspend the balance, Your Honor.
Norman?
That is correct. We stipulate to the violations, and again, we had an agreement to 12 months to serve and suspending the balance of his probation.
I'll accept that as, 12 months to serve and suspend the balance. I'll accept that.
Thank you, Your Honor. Oh,
Willie
Watson.
Watson.
Oh.
Willie Watson.
Okay. Okay.
Okay, I need everybody to step out.
Or just.
Mr. Adams, I need to go to the jury room. Go to the jury room and hang out. Any of you, I'm leaving. I need to go to the girls' room. I mean,
Count. Don't give me a second one.
This is, you don't have. No, that's awesome.
Oh, no, not before.
How are you doing?
That's my soul. Look, I couldn't see.
Right.
I
looked up several times, I'm blocked.
That's what you were doing. I saw you move and I was like, oh.
I was like,
No, he's not this thing little beat. I'm gonna go look.
right.
Look.
Oh, I'm sorry.
Thank you,
You all
guys.
going on break?
I'm sorry, what happened? Why is
Oh, can we
everybody?
mute- Can we mute the,
What we're going to do right now is we're going to mute all the mics. We are just taking a 5-minute recess where we had to have everyone leave the courtroom. So if you just
Gotcha.
give us 2 seconds, we're gonna mute the mics, disable the camera, and then we should be starting back in about 10 minutes.
Thank you, ma'am.
Thank you.
Oh, give me a second.
Oh, everybody left? Where are you? Have to all move the courtroom. Oh, wait a minute, but y'all are not dismissed. It's something that, did you give me something? A judge, oh, here, go, give it, cause I don't wanna mess up anything. And I want, cause he has, then you have to get copies. He gets. Oh, I need to sign this part. I hear you.
Yeah, so it's 5 to 20 on the gang charge.
I hear you, Ms. Carter.
I'm just gonna shut my mouth.
Oh, you wanna do that?
I'm just gonna shut my mouth.
You wanna do
'cause
it
I don't get
Friday,
it, but
huh?
it's not for
I
me to
thought we were
get.
like, so the Friday and you're calling in on the 24th?
Well,
I said,
no, I don't know what day that's gonna be.
so the next day would be the 21st, but you would do following that day.
Litigation.
Because they do it every day.
I don't do it every day. I guess that you want to have the Superior Court.
What are we doing on this, Mr. Norman?
We're taking a
I
whole.
believe we're going forward with the plea. Oh, yeah, and again, I'm gonna call it a semi non-negotiated plea because.
You're not pleading to the indictment, lucky you.
Right,
Well, him.
yeah, he's not pleading to the
Yeah.
indictment.
What is the OR?
Count 1 and 17.
What's the OR?
ORI number, that's on,
That's on the.
what's that program we use? It's on our computer, it's,
Oh, JCATs?
JCAT.
Agency service.
I don't know what it stands for. I've never known what that stands for.
Prime number is like off of.
Yeah, what does it stand for, though?
Originating agency.
Oh, God.
I never, I've been saying ORI number forever.
It's very redundant.
Call somebody.
Oh, agency might be the police agency.
Yeah. That means sounds commercial.
Yes, there is. The two-way driver. Just something that says.
Somewhere?
Serving agent or something. Originating agency, right, I got it.
Yeah, what it really.
That was pretty good.
Right here. That's not all.
Okay, what needs to go there? Agency service. Good people. He wasn't like anything. He was everything. And they killed them to, and be investment. You know, we check. It was just like.
Alfred. We're doing it right now.
Okay.
Sign here that we're doing it, Alfred, only 1 and 17, which is the one gang that we talked about, and the attempted. I don't know if you see attempted armed robbery. So that's the only thing you're pleading to is 1 and 17. They're null processing everything else.
It don't matter about the evidence, and it don't matter in the game.
No, I mean, other options that, like, this is a plea is a.
Yeah, I know. Say.
Right. Yeah, but I'm not able to do printing. It's not easy to do it in that really because
Oh, no.
it's.
That's it, just that one.
Here you go, here. All right.
Oh, I didn't know we were waiting on anybody.
Do we need probation again?
Yes, we could need probation in here, Judge. I can go grab her. I don't know where she was.
On probation, you're gonna get ran concurrent.
Yeah, well, who's your judge for the probation?
Bill.
Hmm.
It will Judge Bell.
Oh, yeah, we'll have to handle it.
Oh, he still here?
Well, no, I don't know who took over his docket, but whoever took over his docket. But it's not, this, she took over, I'm not sure.
I don't know worry about
He's
probation.
not, but
because
she might be back here.
I'm gonna tell you.
It's down 28.
That's where the company was back there, you know? And it locked me. I don't even talk. That's all my doctor. You never go take care of that.
Who don't take this? Who don't take this?
I think you did. This is okay. This is McNabb.
She's coming.
I check it as well.
We're back on McNabb.
McNabb is the only, you only have one case, correct?
Yes, just one.
You okay, Mom? Okay.
Judge, do you want me to go ahead and start as she walks out with the colloquy?
What are we doing?
He's taking up on personal negotiation. Yeah, that's fine with me.
Okay. Your Honor, we're here in State versus DeMonte McNabb for a non-negotiated plea. It's case number 24 SC 002147. Mr. McNabb, can you raise your right hand? Do you solemnly swear or affirm that the testimony you shall give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth to help you God? You have to speak into the microphone so she can take down everything you're saying. State your true, correct, and legal name, sir.
DeMonte McNabb.
Are you currently under the influence of any alcohol, drugs, or taking any medicine that affects your ability to understand what's going on in court today?
No.
How old are you?
29.
How far did you get in school?
GED.
You completed your GED? Are you able to read, write?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged with the following offenses? Counts 1, 2, and 3 charge you with violation of the Street Gang Terrorism and Prevention Act. They're each punishable by 5 to 20 years in prison. Count 6 charges you with violation of the Street Gang Terrorism and Prevention Act. Also, count 7 charges you with the same thing. Those are each punishable by 5 to 20 years in prison. Count 8 charges you with murder. That's punishable by life in prison. Counts 9, 10, 11, 12, 15, and 16 charge you with felony murder, each punishable also by life in prison. Count 17 charges you with attempted armed robbery. That's punishable by 1 to 30 years in prison. Count 18 charges you with attempted purchase of marijuana. That's punishable by 1 to 5 years in prison. Count 19 and 20 charge you with aggravated assault with a deadly weapon, each punishable by 1 to 20 years in prison. Count 21 charges you with home invasion in the first degree. That is punishable by life or 10 to 20 years in prison. Count 22 charges you with possession of a firearm during the commission of a felony. That's punishable by 5 years in prison. And counts 25 and 26, they charge you with possession of a firearm by a convicted felon. They're each punishable by 1 to 10 years in prison for a maximum total exposure of 2 life sentences plus 195 years, sir. Do you understand that?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Okay. Do you understand that if you plead not guilty or remained silent, you will receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer, Mr. Norman, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your lawyer?
No.
Are you satisfied with his services?
Yes.
Mr.
Come on. I know you can speak loud.
Bless you. Mr.
Yes.
Okay. Mr. Norman, do you waive formal reading of the indictment?
Yes.
And do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes, for the purposes of the plea.
Mr. McNabb, I just went over with you the minimum and maximum penalties, what you're facing on this indictment. Before coming here this afternoon, did you also go over that with your attorney? Did you also go over the minimum and maximum
Not today,
penalties
but
with him?
previously. No, I understand though, yes.
Is that a yes?
Yes.
Okay. And you understood everything, right?
Yes.
Okay. Do you understand that neither the court nor the DA's office has anything to do with parole or the Department of Corrections or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you to the contrary?
Yes.
Do you understand that this is a blind or non-negotiated plea and that the state may still recommend a sentence to the court? That the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge you're pleading to?
Yes.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once sentence has been announced?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you?
Please speak up.
Yes.
I know you did. I know you can speak louder.
Do you want to maybe switch
Oh,
with him,
that's
Mr.
fine.
Norman? That
Not
might.
that, but he needs to speak up
Okay,
so I can hear.
I understand. Do you understand that the court's asking you to just project your voice a little bit more? Okay?
Yes.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you're currently on probation or parole, it may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
Yes.
Are you a U.S. citizen, sir?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a gun, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a gun or use one in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
In addition, you waive the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to a court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf, and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. By pleading guilty, you're giving up or waiving each of the rights that I just told you about. Do you understand that, sir?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
We were entering the plea pursuant to Alfred. versus North Carolina.
Understood, understood. So I have some
You said you were entering what?
The plea pursuant to Alfred versus North Carolina.
So Mr. McNabb, I have some follow-up questions for you based on that, okay? Are you pleading guilty because you have decided that after looking at the evidence the state has in the case, that it is in your best interest to plead guilty, sir?
Not really, ma'am.
Stand by.
It's either
No.
are you
Yes.
pleading or not?
Yes.
Okay, I'm gonna re-ask that question, okay? In this case, count 1, gang activity, and count 17, criminal attempt to commit armed robbery, sir. Are you pleading guilty because you have decided that after reviewing the evidence with your esteemed counsel there, that you have decided it is in your best interest to plead guilty?
Yes.
Are you aware that even if you do not admit guilt, this guilty plea places you in the same position as if you were convicted by a jury at a trial?
Yes.
In indictment number 24 SC 002147 to count 1, gang activity, and count 17, attempted armed robbery, how do you plead?
Guilty pursuant to Alfred.
Guilty.
Pursuant to Alfred.
Pursuing Alpha.
Guilty pursuant to Alfred, okay.
Okay.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you, sir?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that unless counsel is substituted or permitted to withdraw, Mr. Norman will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
Do you understand you have 30 days from the day of your sentence today to file a direct appeal?
Yes.
And do you understand that you have only 4 years from today for the felony charges to which you're pleading to file a habeas corpus petition, which is a legal term addressing your ability to address any constitutional challenges to your guilty plea?
Yes.
Do you understand you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes.
And do you understand that any of the filings we have just discussed must be filed by your counsel unless you are representing yourself, sir?
Yeah.
Your Honor, the factual basis is as follows. On April 12, 2023, at approximately 11 at night, armed robbers Demetrius McDowell, Keontae Jackson, and this defendant, DeMonta McNabb, fatally shot their co-assailant, Calvin McDowell, in the driveway of a trap house location located at 1591 Woodland Avenue in Southeast Atlanta. Lead Detective Terrence Malone interviewed the victim of the attempted armed robbery. His name is Jarquavius Everson. Mr. Everson explained that prior to the incident, he and his friend, Roderick Butler, were at his trap house residence playing video games when he heard a knock on the door. When they opened the door, they observed Calvin, the decedent, and 2 other men who were unknown to them. Mr. Everson said that he and Calvin had previously negotiated the sale of 3.5 grams of marijuana. And when Calvin arrived to make the purchase, he began to prepare the marijuana. At that point, as the marijuana was being packaged and prepared, Calvin brandished a weapon and attempted to rob him. Mr. Everson then said that he immediately tried to disarm Calvin, and during the ensuing struggle for the gun, one of the unidentified co-defendants opened fire. He then explained that he successfully got Calvin's gun from him, and at that point, Calvin had been shot with the firing from one of the 2 co-defendants, and Calvin was crawling back outside the door as the 2 co-defendants running back to the car were still continuing to fire rounds towards his residence. Everson actually got shot in the course of the gunfire. Mr. Everson explained that although he did gain control of Calvin's gun, that he was not one to fire at Calvin, shooting him. The detective spoke with the last person who would have spoken with Calvin prior to him going to that incident location, and that person said that Calvin said he was going there to commit an armed robbery. That was the plan for that night. After his arrest, Demetrius McDowell, the co-defendant, named this defendant as the driver of the getaway car. This defendant, Mr. McNabb, was the one to pick up all these guys, take them to this location to do this armed robbery, and then was the getaway driver in this case. On April 29th, 2023, Detective Malone interviewed the owner of the vehicle Mr. McNabb was driving. That was her boyfriend. She said, essentially, Judge, that Mr. McNabb stole her car and she tried to call him to get it back and he refused to return it. And then the following day, she saw it at her house in the driveway with bullet holes in it, is what she told the police. And we have jail calls where this defendant is admitting to his mom that he was the driver of that vehicle when the armed robbery happened. And as I told the court earlier, these defendants went into his car, one armed with a huge rifle, which shows that indeed Mr. McNabb was fully aware of this plan to rob this drug dealer, a plan that went tragically south. The defendants are associated with the Bloods, a criminal street gang, and also with Paradise East, PDE, and One Gang, which are blood subsets. And those gangs are known for committing violent crimes like these crimes, aggravated assaults, and other violent crimes, Your Honor. All events occurred in Fulton County. And Judge, just as I did at the last plea, I do want to just put on the record, seeing as how someone died in this case, that the circumstances surrounding the null process of the murder. Of course, if Mr. Calvin McDowell had survived this, he would have been on an armed robbery indictment along with this defendant and the other co-defendants. And although they went there fully intending to commit a violent armed robbery of Mr. Everson, the evidence does not show that anyone meant to kill Calvin McDowell, but that's the way it works in these felony murder cases. That's all I have, Your Honor.
Mr. Norman?
Your Honor, as stated earlier, this is a case where we are requesting a sentence of 20 years to serve 5. And the reason for that being that, with all due respect to the state, the way that they're portraying it is not the way that that day happened. Mr. McNabb was the last conviction he had since 2014. I believe he was 19 years old. Since then, he had been working, doing everything he was supposed to do on probation. This particular day, he had his girlfriend's car, was riding, ran into these friends. They went to several places. They didn't just get in the car and say, we're going to commit a robbery. He drove them. At one point, somebody needed to help their girlfriend get a tire. So there were several stops before this. This was not a plan that he got up in that morning and said, this is what we're doing. I told him the mistake he made was picking up the 3 young men in the back seat. Mr. McNabb and Mr. McDowell are much older than the 3 gentlemen they picked up, which are Mr. McDowell's younger brother and his friends. Those were the people who set up the marijuana sale, who went in, who did the shooting. By all accounts, Mr. McNabb sat in the car, did not have a weapon, never got out the car. We filed a witness list with the young lady. Mr. McNabb has always represented to me that when the shooting started, he ran and the car was brought back to him later with bullet holes in it. Although he was there, we're not denying he was there. But because he didn't know it was going to happen, he ran from the scene, and we have a witness on our witness list that was going to testify that, yes, he came to her house on foot and the car was brought back by Mr. McDowell later. So given the fact that he had been on the right path, his mother is here. She is supporting him and will help him whenever he is released from prison. We're just asking in this case that the court take into account what Mr. McNabb did and what he also what he did not do. And give him the minimum sentence in this case, 20 to serve 5.
Anything else from the state?
Yes, Your Honor. So we are asking the court to sentence Mr. McNabb to 30 years to serve 10 years in confinement, judge, with the balance on probation, with just a few terms: no contact with the victims, family members, co-defendants in the incident location. Also, no further contact with any associates of any criminal street gang, no more criminal street gang activity. No guns or replicas, Fourth Amendment waiver, and no drugs or alcohol. Given the fact that Mr. McDowell got 12 years this morning, I believe it was this morning that we pled him, and he actually went inside the house. We thought 10 years for this defendant would be fair because he was the driver and he did not actually go into the house.
Oh, and I apologize. I don't know if I said it or not, but my point in separating Mr. McNabb from the 3 gentlemen in the back is that those are the ones who have the gang tattoos who are associated with Paradise East.
There would be no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no social media, no further contact with any gang affiliates, gang members, or any known members of gang. No further contact with Keontae Jackson, Demetrius McDowell, Fabius Epperson, and Roger Buck.
No, none of them people.
Roderick Buck. And no contact with any of their family. Enforcement of waiver. And I'll go with the state's recommendation. It's 30 years, 10 to serve, credit for time served, and then on count 1, and then 30, is it 30, 10 years to serve on 17?
So count 1, Judge, that the max is 20, so it could be just like a 20 to serve 10 or a straight 10 to serve, and then the 30 would be on the next count, run them concurrently.
Right. Oh, and it'd be 30 to serve 10 on that one too.
Yes.
All right, so we'll do 20 to serve 10 and then 30 to serve 10.
Thank you, Your Honor.
That's what to serve.
Thank
Yes. Done as well on the.
Okay.
The docket is 14 SC 126 5.4. The charges originally were robbery, act assault, and possession of firearm during commission of crime. There's 3 years, 7 months, and 10 days remaining. He entered today, Your Honor. He's subject to revocation, and I'm asking for the balance.
And I would just ask it to be concurrent with the sentence the court just issued. This is the 2014 case, which I discussed earlier.
All right, we'll revoke the balance. Thank you.
Thank you.
That's all my business, Your Honor. May I be excused?
Yes, ma'am.
Thank you, Judge.
Yeah, next.
All right.
Can I make a couple of announcements?
Yes, ma'am. There's on the plate, I write it down.
Yes. We could start with position 17.
Dimitri Davis, 24 SC 004
Yes, he is on Zoom today. In speaking with the state, there is plans to dismiss this case. However, they have to reach out to the alleged victim to advise them that they're dismissing the case. So at this point, I believe we would have to ask for a reset for that dismissal to happen.
What says the state? Please give Brown.
Mr. Brown here.
He just went right there.
Try to grab him.
Sorry. I'm not sure.
I know he's not feeling well today.
Okay. You have a date?
I don't have.
They're gonna, we could pick in contact. I'm just gonna call it in with me.
Okay.
I'm not, it's
Mr.
not going
Adams,
to.
not ready for a plea. You are,
Okay.
Judge.
Is he coming?
Yeah, he's working.
At 3 years, 1 month, they want to go 2 years, and 1 month and 29 days.
Yeah, but 2 years. That's what I'm saying. And they want to vote all of, yes. Oh, I've been saying.
Which is your client, Red? Which one am I?
Warrants. Oh, my lord.
Yeah, we're gonna take that, we're gonna, Ms. Watson and take this plea. And you kind of jumped up.
I did because everybody needs to pick up children. I've got people like, I've not resolved any of these cases. So I just want to make a record of it. The state, I've
That's fine, they're gonna be on 2-hour call. Cause some of these are resets from last month, right?
Mr. Davis is, yes.
Yeah, okay. I remember his name.
Mr. Davis is reset from like September. Yeah. Mr. Davis also lives out of town, so we'd actually need especially set, it's just if it's not dismissed, wouldn't imagine it's not going to be.
That's the case with them, it is.
This position 17. Every day. That correct, we need to, so you have victim contact.
Right, correct.
It's my understanding they plan to dismiss the case as well.
Yes, Your Honor.
All right. I guess you just let Ms. Woods know there's a victim contact and we'll show it later.
I will get in contact with Ms. Woods once we've made victim contact and.
Well, I'm gonna follow it in, so your investigators need to be.
Position 25, Antonio Stevens. He did appear via Zoom from Coastal State Prison today. They have since left the Zoom. That was also a request to reset. He is serving a sentence. There's no drug labs in the case that can be found at this point. We are resetting it to potentially find those drug labs, and we're also hoping to enter a plea to run concurrent with the sentence he's currently serving.
So if they haven't tested everything?
We're not sure yet because there is none.
We'll check GBI and pull the report so we can forward it to defense counsel.
Okay.
Position 28, Carlos Barber. We are requesting a reset for a hopeful global resolution. He's got 2 additional cases. That's 24 PI 005278, in addition to 24 PI 005154. Position 31, Notarius Gaither. Mr. Gaither is going to be entering a plea. That plea will require him to turn himself in to serve a year in jail. He's not prepared to do that at this time. We did request, I believe we requested the March 21st date. I don't know if that's still available for him to come back to enter that plea and turn himself in.
Ms. Woods?
I gave him a date earlier.
Okay. All right.
Position 32, Maddie Wright. The state, it's a mandatory minimum of 10 years on armed robbery, Your Honor. The state is willing to reach out to the victim in the case and hopefully drop this down to something outside of a armed robbery, hopefully a robbery or a theft by taking. So with that said, we would like them to reach out to the alleged victim for a lesser sentence in that case.
Okay.
And then lastly, I have Mr. Gregory Adams. I did reach out to the adult diversion program. I'm living on a hope and a prayer that they accept him into that program. We have not heard back yet.
So you still on McGirt?
McGirt is here. He's going to be entering a plea. And everybody else that I have on the calendar, we've got pleas worked out. And I want to approach the bench on just one case, and we should be.
Let's do it so it's Friday, right?
Yeah. Can I release everybody else that I just read off?
Yeah, absolutely.
No, that wasn't him, that was the other.
Okay. Now, what do you think now?
They told you were acting up, they put it to your name.
This is position 1 on the probation revocation calendar.
For one?
Yes,
Willie Watson?
this is William Watson, yes. And Your Honor, are you ready? Oh, and in this case, Your Honor, what I'm asking for is to reset the violation hearing. I spoke to Mr. Watson in the back. He expressed to me that he was on medication for depression and some other things, and that he didn't understand what's going on. That medication affected his ability to understand, and so I'm asking for a reset based on him making that representation to me.
He's on medication today.
Yes, Your Honor.
What says the state?
It's the probation revocation.
For which?
Watson.
Watson.
That's not,
Watson.
oh, that's you.
That's not even her, his, that's actually, Olivier's,
Oh.
based on the charge.
I thought she was on here earlier.
Talking about Willie Watson,
Yes,
it's a gang,
it is a gang
gang
charge.
case.
So we're just asking to reset it.
Let me ask you, is this something that you take daily?
Yeah, it's my choice to take or not.
Okay, something that you're supposed to take daily.
Yeah.
Okay, so,
No, not it.
I mean, antidepressants kind of work like that. You take them daily. You don't just
Yeah.
say, feel kind of low, I'm gonna take an antidepressant. So what's the difference between you taking the pill every day and then showing up?
I don't take them every day.
Your
I
Honor,
didn't even know I had court this morning, man.
Your Honor, probation opposed to the reset. I spoke with the defendant about the revocation, the violations that have been before the court today. He seemed very engaged, had multiple questions about the time remaining in probation. He's to be very aware of what's going on today. After the service of the petition, stated to his attorney that he had some type of emotional depressant that he took, and he didn't understand what was going on. So I'm oblivious to what's going on, like this state to the court at this moment. So I really don't understand.
And all I would argue, Your Honor, is, I mean, I have to rely on what he's telling me about whether his medication affects his ability to understand.
You on that medication on January 27th? Last time we were here?
I wasn't here January 27th.
When is Casey on the January 27th council? I think it was, man. Okay, so this medication, you're supposed to take every day. If you want it to work, you're supposed to take it every day, not just.
I know I just got on this medication though. Probably 40 days ago.
All right, over 30. What is it that it's doing to you?
Having me drowsy, having me not remembering stuff. That's why, like, when he came back there and said I had like 3 years on papers, I thought I probably had 2 years on paper because you sentenced me. So I'm really like confused on how much time I got left and all that.
What did you didn't understand anything the probation officer told you?
Yeah, huh? Yeah, I told her the same thing.
So is it you didn't know?
She said she don't know if she got the time right. That's what she said.
So the defendant said that he took a plea for 3 years, but that 3 years included an additional 11 months.
Right.
And deducting that time from the time that he took the plea, the time remaining is the time that it is. And the defendant stating that that's not accurate and it should be less than what it is.
And what the state was proposing, if we stipulated, was to revoke 2 years, 1 month, and 29 days. When I tried to explain that to Mr. Watson, he told me that the medication affected his ability to.
You don't understand 2 years, 1 month, or 29, you don't understand that?
No, because on this paper it say 3 years, 1 month.
Okay,
Yeah.
that's Woods.
Goodbye.
You're gonna just sit there in jail?
No, what I'm saying is on his paper right here, it say, oh,
What I'm saying is, you're gonna sit there in jail until they bring you back, so you're not getting out today.
no, I'm not saying this because I'm getting out today. I wasn't saying this trying to get out today.
Okay. Been on this for 40 days, so have you constantly been tired and sleepy for 40 days?
Yeah, kinda. That's why I don't try to take it every day. They had me like drive, they had my battery light down. And I told him I had one of my transcript. This my first time even talking to somebody. Right before I just walked in the courtroom.
But Ms. Brown talks to
Right before I just walked in the courtroom.
So he has to plea. He was first appearance on January 13th. He took this plea April 26, 2024. He hasn't even been in 4 years. I was getting ready to reach out to the prosecutor and ask if she can, but unless, Officer Brown are you expecting Mr. Ruggiero to handle this revocation, or are you doing?
I assume they will be here.
She probably didn't know.
And I'm just trying to figure out, like, if he takes it every day and then the next time he comes to court, he takes it.
I got my own personal opinion, but I won't say anything. It's been an open court. I'm not sure anymore.
And I will state that the defendant has three different credits towards his probation time. There's one for 131 days, another one for 138 days, another for 96 days. Add those up, those are the total amount of time the defendant has credit for on his probation based on the time he's been in, prior to being sentenced, and any additional credit that was granted. So that time has been computed. What's left or what's remaining is what's remaining.
And they are offering to revoke a year less than that, although the original request was to revoke the full amount. Because he said he thought he was sentenced to something less, they were gracious and removed that extra year. But he has told me that he doesn't understand, so I can't.
So are you ordering a psych or what?
Yeah, we need a psych eval?
I ain't order nothing. Didn't come
did you
here.
call Martin?
Oh, you talking
No,
him?
I'm not requesting a
sorry.
psych eval. I think he would be common and proceed. I would just ask for the reset based on him explaining to me that he.
But you understand, Mr. Norman?
Before we do reset, Your Honor, I do want to say the defendant has been on the APD repeat offenders list for 3 years straight, 03, 04, and 05. And reducing my recommendation for a year is more than generous. And that it will not change upon a reset.
Yeah.
So that's what I'm saying. He takes it again, and he keeps taking it, and you're supposed to take it every day, and every day you say it makes you sleepy or you can't remember anything. What's gonna be the difference in a week? That's what I'm trying to figure out.
I mean, I don't even. Could you hold on? Could you explain how much time do I have left on probation? Because you originally sent me to a 4-1 after I was locked up for a year. And I've been out a year. So I'm trying to see how I got 3 years left. That's what I was asking him.
It's not that you don't understand what's going on. You don't understand the math.
And the issue is that the paperwork said there was a 5 to serve 1, not a 4 to serve 1. He keeps saying it's 4 to serve 1.
She sends me.
I mean, whatever's on there is a Senate sheet. That's all.
Yeah. So
Ms. Brown, it's 2 years, how much?
The time remaining is 3 years, 1 month, and 29 days.
but if Mr. Watson is willing to stipulate, there was an agreement to revoke 2 years, 1 month, and 29 days.
So they're coming off a year, if you want to stipulate now.
And the balance will be terminated.
The balance will be terminated.
Ma'am, could you
They
hold
will
on?
reduce your sentence
No.
by a year.
I know that, but could you look at transcript of when I was sentenced and what you sentenced me to? That's all I'm asking.
I think that's transcript.
The plea was taken April the 20th.
I believe I looked and I didn't see
2000.
it.
You said April 6th? April 26th, 26th.
Probation revocation.
Can we move on?
Yeah. We lost the private phone because they got a verdict, they could be there.
All right, go take a verdict. Sanders.
She has the, what you call it, she has the, I don't even see it.
And then that came out me, Miss Sanders.
No, they're not ready.
I got 3 years and she said she'll take off here. If I ain't got number 2 years remaining, she take off here. I'll take 12 months. You know what I'm saying?
Yeah, she ain't gonna do that.
But I don't have but 2 years.
Yeah. You know what I'm saying? She wants to work the whole day.
No. Oh, no.
Okay.
Am I looking at the right case?
So it's not a question, it's.
What are you asking me? What are you asking me, bro? What are you asking me?
Yeah. She said this is the lowest you go. 2 years because of your history. And a different thing. You're already out. You took this plea in April.
Cause this is an inconvenience.
Another offense.
Oh, we can't do that. We'll have to go for it. Take my back. I think I remember this place. Take care of Mr. Adams. Keep going.
I'll wait and get for
I don't know stuff, but I'm not one of these.
Hey, Smothers, is Mr. Norman out there?
Oh, you need
Norman,
Judge?
is he out there?
No,
Oh, he went in the back?
I don't know if he did, Judge.
That's so, come on, let's go. Right, we got him, get him.
Thank you.
No.
Yeah, I just. I don't know if they went down.
He
to
offered
take
There he is.
5 years.
Get your point, let's go.
Probably
Let's
not
do
for
it.
first offender.
Okay, which one?
If we can't get anything better,
Mr.
I
Watts.
asked for
Oh,
just
okay.
the misdemeanor
But Miss
on
Olivia
it,
is on
and he
there.
said no.
I
But
am
I'll just
ready.
keep pushing my luck on that.
I
Judge,
gotta
which one you
apologize to
doing
Miss
first?
Olivier again.
We're gonna take, oh, it's Willie Watson, he's on the, probation revocation. Miss Olivia, you there? So Olivia, are you there?
Yeah, Mr. Watson,
Yeah, he great.
and a printing indictment that I can't get to print. You try, well,
No, come on, you got this.
I'm at, that's that, like, sure.
I asked for indictments earlier from people.
All right, for some reason, I can't get out to see the print them.
You ever get on that?
I think we get on, but I can, when I print, I gotta print it and nothing's there.
This thing, I have to install something.
All right, here we go. We're back over, Norman.
Yes.
Mr. Watson, listen closely. I don't think that you're under the influence of drugs at the part that you don't understand. I think you are not understanding the math, that you understood the math when you pled. You were sentenced to 5 years. We suspended 1 year. Take one off, then there was 4.
I know I took a 4-1.
Look, it's so it's 4, okay? 4 years of probation. So you're right, there's 4 years of probation because 1 was suspended. All right, let's do it, Ms. Brown. I think you understand what's going on. I think, but I'm not
No.
arguing with you about a sentence that you pled to then. Go ahead, Ms. Brown. You want to revoke, 2.5, 2 years?
2 years, 1 month, 29 days, and terminate the balance.
All right, anything, Mr. Norman, anything else?
Nothing that I already said. I would ask for, 1 year on behalf of Mr. Watson.
Yeah, okay, so I'll go with the, Ms. Brown's recommendation, 2 years, 1 month, 29 days, and the balance will be suspended. So once you complete that, you're done. Completely done. All right, best of luck to you.
Oh, no, hold up. Ma'am, on April 24, I got sentenced to a 4-1. I got a transcript of what I got sentenced to.
You got sentenced to 5 years probation. 1 year was.
No, I didn't get sentenced to 5-year probation. I came for, I had 10 charges.
5 years probation, 1 year.
I have paperwork saying that it's 4. I don't know why he ain't got it.
The paperwork I have says 5 do.
I know, and the paperwork I got say 4.
Thank you, Mr. Watson.
All right, come on, I ain't had nothing to say like. Can I put on the head? 'Cause this man
Omar
ain't
Juarez.
Come on, bro.
Okay, go ahead.
Today's Wednesday.
No.
You want to ask no comment?
Yeah, he gonna come.
I'm not
You got this, you ready to sentence?
They wrapping up, yes.
Okay, Miss, Carter, who you wants to bring it in?
I need to do Mr. Davis first, but I also need Miss Hall on.
We have McComb.
And then,
Oh, Marshall Hodge, I think. Is she on?
yes, she is.
We can do McComb so we can get Miss Hodge. Is that the last thing you have, Miss Hodge?
I'm here.
So there's Miss Hodge.
We have Durwood McComb's plea ready, and I think that's Miss Hodge. I don't know if she has any, if she's waiting on anything else, but we could get her out of here.
Which one do you
No,
have?
that's the only thing I have.
Okay, so Durwood McComb with Miss Hodge. He is position number 4 on the final plea and trial calendar.
Last to get served 4 on the final plea. It's.
I got him.
Okay.
Do you want me to give you my order after? Because I think it's gonna
Durwood
be
McComb.
Mr. Juarez, then
He's
Ms.
been-
then Michael
Well, we need-
Norman's case. So you know that Mr. Adams is going first with Juarez.
Oh,
Then you're
sorry.
on deck with, who's this?
McComb.
McComb.
Oh, I thought we were
And then
having a
I'm
break.
this call for, Davis and then McGirt. Baines and Housley, and Baines and Housley are online.
Okay.
And then I'm approached about Mr. Matt, he's got 3 cases. I just wanted to run the non-negotiated value. Because if it's gonna be, it's just gonna be, where you're gonna go with the state's offer, then you would just be ready.
Okay.
Okay, so I don't wanna waste everyone's time to go through the whole entire plea colloquy, and it's gonna be like, no.
Are you guys
30,
bringing somebody
20.
up now?
Ms.
Are
Carter.
you bringing somebody up now?
And then, and then Mr. Saunders for probation revocation.
Give her 1 second, they're doing a sentencing measure. And then that's it,
Yeah,
then that is it.
yeah.
That's my mitzvah look that. See,
Your mitzvah?
my mitzvah letting her use candy.
I think, look what we got.
Oh,
Yeah.
she's here.
He's not gonna resolve.
That's awesome, Laura.
He doesn't take the thing and he's gonna go.
Yeah, hi, Judge.
Hey, how are you? So,
Good. I was just talking about calling you. What, you're here? What you want? No, we're just, I was giving an order of things.
oh, all right, I thought that would be Juarez part. Number. The thing like there. 36. I said things like boss had here. First one, no.
This part is the same order that we talked about earlier. No, I changed it because Mr. Davis has to get out of here, but they got Juarez with Mr. Adams and Ms. Nix. And then Michael's got one with Ms. Hodge, and then we're gonna do Davis, McGirt.
No. So I had reached out to HP before I drove up here and she said that she was lining my police area. And there was one plea, y'all said, where's she? She in fact,
Mr.
yeah, because I still have an appointment, like, I can't.
The judge has one.
She got Juarez, McComb, Davis, McGirt, Baines, Housley, and Saunders. No, I have to go.
I know I'm not getting in front of Mr. Adams, so.
But we might have to just research my case.
Did you want it?
Hello?
No.
So can we use that? I'm here at the line and I move my. No, I'm on time here, they said, there's these other.
What's that?
I still have, I pushed my appointment back. And then, so.
Oh, no, he went in there.
Oh. I don't. What you can get, Adam, I can go.
I want no.
I drove up there because I was driving to an appointment. That's why I actually. But we're gonna have to like.
I know what's going on. It's, I gotta go back to where people pay me.
It's just been this.
I thought it was working for the people, but this is.
It's just been this round. It's been since, the new year.
Yeah, it has.
It has, because I feel like we went into the new year fine, but since all these final pleas have been really bad these last,
Yeah, but
since the start of the new
so
year.
I know everybody's getting smart about being there since 9 o'clock, but I don't pre-track cases before. I did all these before today. And.
Oh, it's me. I thought we were talking. This shit is just crazy. He wanna argue, he was like, you ain't talking about my case. I'm like, they asked for 3 years. It's down to 2. I obviously talked to somebody. Like.
No, it ain't that. I need to stop.
No, she was down to 2. He kept saying he doesn't have 3 years left, but like, it's like your sentence is why I do. That's what she said. So the judge just looked up. He's arguing about what sentence he took.
Yeah, but all my cases have been ready to call it out. Ready, please.
Hey,
It's now 4 o'clock.
And then
So, yeah, he in a wheelchair.
he took a plea in
I'm in
April.
a wheelchair.
In November. Like, he didn't make it a full year. And he got like 6 prior, like it's, and then we don't have, I don't know what he wanted me to say.
I just.
But I'm not
Time
gonna,
myself today.
when they approached me with that fuckery like he did, like I got home, then and yeah, I'm gonna get up.
It's so unfair to me.
We do what I do.
No, I'm in the courtroom. That's what I'm here. I drove here because I was driving to my appointment.
That like, and like, they have two attorneys, and so they don't realize.
I don't know.
You know,
Because I think this is unfair.
And then you don't have people. She answered the phone, we return phone.
It was a I'm about to call agents, and see if I come over or whatever, because we might have to be sick. I just got charged for retarded. I can't come back, I'm not spending $100 because.
What's the lady's name at the front desk?
You know, I'm gonna try to get
Hanson is last.
That's what, let me call agents for station.
Yes, I see. Okay, so let's finish.
What I say, birthday.
But in charge, not at home.
Reason that you're in trouble.
This is.
He won't listen to anything. He's like, you ain't told me. I was like, I tried to talk to you. And you acted like
None of this stuff was here. I have a trial, a murder trial on Monday, and I couldn't meet with nobody because I'm sitting in court.
would you write down what it is?
Except after that, we found hold on to it.
Do you have to go? Yeah, because Michael's will be here next week. I'm not here. Today's my last day in this court, my last day this year. My case will be seen and I'll be reset. I've been here.
If we need to reset that, I'd like to just tell them.
Yeah, I can do it next.
Waiting.
I'm not done, I'm trying to talk from next.
But I have a man that needs to get pick up child. So I'm just saying, if you're going to leave.
Charlotte, this is kind of your, you kept saying pre-trial and stuff and you already had planned.
The only person I asked for pre-trial was Mr.
Davis.
No, I knew that, wow, but I also knew Mr. McGregor.
So because we weren't ready, we couldn't do it.
I knew we were gonna take my police before, and
Yes, we weren't already.
I didn't know.
It
That
don't
was
matter what you know, it's what I know, you make us, I'm like, what is she doing?
That was, because I needed a pre-trial back, I needed to talk.
You said you was looking for
I didn't need a pre-trial with you, I just said, I need to talk to Mr. Mack, and I need to talk.
But this is how we, there's always some long delay in your cases, I mean, 1 file, they were all extra out.
We can
I
use-
say this. Because of what you did.
Yeah. I can reset it.
I don't have the power.
Okay, but if you need to go. So I can ask the judge to reset the case.
No, I think we're waiting on April to come out. That don't really matter, I can't do nothing, it's not a court reporter here, so.
Yeah, they're taking the sentence.
Maybe. I don't want her to like miss her stuff.
Yeah, what time's your appointment?
Oh, it was at 2:30, Judge, and then I called and had to push back to 5, after I paid $50, I had to push back. But I had.
When's yours?
I've got Mr.
Oakley, Mac, McBride, Davis, Baines.
So, I mean, I can reset them.
And because I came out last
Let me see how that going next door. Hey.
Like when I tell you, this is like I'm over left. It wasn't happening to me. Right. It was like this is my first city. Oh man, no, that's a whole different. That's a whole different animal.
She gonna do it, and then she will do it.
It's a really special level. Today is a special level of Becker. I never would have guessed it. Like, for things, because like for me. Right. So you feel civil litigation. Like, what you doing with money? I had more preparation, you know, getting the civil litigation treats them more like a real. Because I don't know, that's crazy. No matter what. She has something about somebody who look like a big for years. Like, that's time, right? And then like. I have these things. Like, all to the purpose of your life.
Which is a lot of things, sometimes they are much more complicated, so you don't, I don't want to blow up and then it issue. Hey, my man, we got it. It's Friday. Do you have following on there? Are they interested?
I just started.
They gonna come, cause you know they interested. We should have just took the home already. Figure out.
Part of it.
Yeah, but she don't want no class.
That's 3 hour drive. Where we finished.
Oh.
The lady who fits over here.
Watching the film.
Where was she?
I already know what she do. When I saw you talking, I was like, what is she? She goes,
Like you said,
what you know?
You
didn't know. Her fault. That was big. Stick with Marshall outside. He just sitting here not doing nothing.
I saw her on the Zoom and she was like,
When she called,
I'm so proud of research.
yes, there's.
You know, I don't know what to do. That's all. All right.
That's whatever she does.
Okay.
Yeah, but it takes a while to get out of it.
Yeah, so I have to.
No, I do not.
Go out on the street and get their way there.
Well, if you have, I need to have a little.
Whether you're released from my car.
what?
Hey,
You
looking like you did waste the line.
I don't know, maybe. That's up to the judge.
Like, oh, when you come into the. Even if she does the order today, and send them to like. So, yeah, I'll go home.
No matter where he wish to live. No, anywhere he wants to. I do that all the time.
Did you say?
Yes.
So what I'm saying, if you're.
But she's acting.
Because no, so my. But my.
Thank you.
I can't, it's over though, luckily.
What's up?
It's like a relationship, a bad relationship that we broke up, so. But I don't know, this is. Who's the new person taking over? Oh, they're back there. Come on.
That she was born.
Wait.
No, not just saying. I thought that would be, I was like, oh, I have plenty of time to get there. Cause I took the train. I was like, should I drive right now? I'll take the train. I'll be home by like 3:30. We'll go. Man, tell her to take the damn, I might have to send her a car like I did last time.
Or you take the train there and take her.
I'm gonna have to, and this around this traffic. You know, I'm gonna send her.
Oh, I think you might.
Let me just send her a car. I'm just
Do you,
sending her a car.
going, I think going up,
What's
you'll
the-
be able to get there
I'm
on
gonna
time.
just send her a car. What's it, Black Lane? Is that the name of the people?
I use Uber, so I don't know.
Oh. No, the people are standing there with the little sign, that's.
Oh, that's nice.
It costs almost the same as Uber at the end of the day. It's like, might as well get the service. That's what I feel like. If you're gonna pay $20 more, might as well have somebody standing there waiting for you. Yeah, today is just, I can't. Today was just today. Again, I can't stand it. I don't understand what's going on. And I'm like, if you.
That's the same thing I have.
And then he was like, I want you to file my appeal. I'm like, I'm absolutely not going to file my appeal. What's today? The 28th. We have a thing on the door. We're gonna unlock with our phones.
Oh.
I got it on Amazon. It's really pretty nice. Our waves. It goes on the inside, so you don't have to change the outside lock to get broken, so they can't yell. Ooh. Oh no, I'm not gonna do it today. The price has changed. Today it's $173.
Yeah, you get on that train and
Yeah,
meet her
no.
at the airport.
Yeah, I'm gonna go get it. Sometimes it's like $99.
But sometimes going up is faster, like going south.
For the federal, just I would say, that you guys worked on the, consider 7 pounds of barrel, how you know the drink of pounds. Okay, took it on the record. Okay. And then, you know, 50 years, I'm part of the thing. It's like, because he's like, you guys, video. Yeah, no, he's on video. Video.
Give me like a cocktail.
What was the verdict? On all counts? Oh, wow.
Well, I'm saying is that, like, for me, probably be on my moves, I was like, no.
I think Ms. Hall said something about maybe she has to leave, so. Ms. Woods?
I'll get it.
Yeah, it is, yeah. I don't have.
Hey, Smother.
All I can tell you is this is my sentence said, he's a big dude, he's a big. Yeah, I mean, he's a man. I had nothing
You
to
mean
do
when he
with
was in prison for?
I wasn't there, like. I just
I'm
didn't
ready to
know.
get started. Because everybody else will be gone now.
I forgot all about Mr. What's his name? Again, he's another one.
Ready, Candace?
Sure. Juarez.
Flores.
He's still the one.
Boston's number 36. 24 SC 005.
I was like, I ain't really about to pass me through it.
This negotiated?
Yes.
Yes.
And Judge, while the defendant is coming out,
Nah, not this part.
I don't know. I actually submitted this case for reindictment this morning because there was an error in the language of the count one. Does not appear as though the new indictment has been filed, but it should just get a -01. It's not changing any of the counts, it's just changing the language.
Yes.
Okay.
And I showed Mr. Adams the draft new indictment. So the only thing that is changing is just really just a small bit of the language. And so I just wanted to make sure that Your Honor was aware that the case number might change. But I think it should just be a -01.
Okay. All right, ready,
So
let's go.
what indictment is he signing?
That's
That's what indictment is.
yes, that's the
She'll try to find it.
Okay.
Let me get it here, right?
yes.
Okay.
To my office.
All right, go ahead.
I know everybody's having a fit, I know everybody's crying, but
Follow you,
I-
just ask a question.
I don't know, whatever Cassie decided to do, I don't even hear.
Go ahead.
Okay. Mr. Juarez, please raise your right hand.
Sorry. What is your name?
Sorry?
What is your name?
Oh, Megan Nix, Nix.
So
Oh,
that I have you properly on the record. Yeah.
If you're not gonna eat it, give me the kids go.
I'm just gonna bring you back.
Okay.
Back on it, Mr. Roy, raise your right hand.
right. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please,
Louder, okay?
Yes, ma'am.
All right, thank you.
please state your true, correct, and legal name.
Omar Noel Juarez.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am. No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
The age of 25.
How far have you gone in school?
High school graduate.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offense, aggravated stalking?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to this charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Mr. Adams?
It's fine. No. 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 No, ma'am.
Are you satisfied with his services?
Yes.
Mr. Adams, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea?
We do.
Mr. Juarez, do you remember having been arrested on this charge?
Remember being arrested?
Yes.
All right.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? State recommends a 5-year sentence to be served on probation. Special condition is no contact with the victim, Zaria Geter. That's ZHARIAGETER. Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the possible sentence on each charge?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty?
I'm sorry, could you repeat that?
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
Yes.
Do you understand that your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked? You could be adjudicated guilty and resentenced up to the maximum sentence for each charge in this indictment.
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of aggravated stalking in 24 SC 005127-01?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that you have only 4 years from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on August 23rd, 2023, a Fulton County State Court judge signed a bond order, case number 23 CR 005153H, which ordered the defendant Omar Juarez to have no contact with Zaria Geter, who is the victim in that case. The bond order was still in effect on September 7th, 2024, when Mr. Juarez went to the residence that Ms. Geter shared with her mother. That address is 3561 Potomac Terrace in East Point. While Zaria was inside, Zaria called her mother, Vanessa Geter, who returned home with her boyfriend, Quius Person, Queius Person, and Miss Vanessa Geter and Mr. Person confronted Omar Juarez as he was coming out from around the side of the house. Miss Vanessa Geter reported the incident to East Point Police, and that occurred in Fulton County.
Mr. Adams?
I have one second.
Sure. Go ahead, Mr. Adams.
Yes, Your Honor, he entered this plea, can't talk, apologize for it.
All right.
The victim is here. I've had a long talk with her. She sent an email to the court, I believe. She wishes to see him. They still see each other. I heard the station, no contact. We'd like to just be no violent contact. Other than that, he is gainfully employed. We ask you accept the recommendation.
Where is she?
She's in the back, Judge. And I'll add that the case, the state court case, the 23 CR, in which the defendant violated the bond order, he did subsequently plead guilty in that case, or it might have been a Nolo or a Alfred, I can't remember. There was a permanent no contact order entered in that case, which is to stay. I did speak with Ms. Geter about that and told her that if she wants that to be removed, that's something that she can talk to the solicitor's office about, but that it is still in effect. And I did tell her that no contact means no contact, that even if she wants to have no contact with him, that no contact is in place and he can be held accountable for having contact with her, even if she wants to have contact with him.
Whereas my suggestion to you is find another girlfriend. Period. Because she's gonna get along with you, she's gonna call you over there, honey, baby, I love you, I love you, I love you. The first time you make her mad, she's gonna call 911 and you're gonna go to prison for 5 years. Find another girlfriend. I need a verbal yes.
Yes, ma'am.
All right.
I
Sorry,
understand.
Ms. Jeter, but I'm not gonna go against any state court judge's order for you to stay away. And that's part of the penalty, you violating those bond conditions. Ms. Jeter, you should probably go off and find another boyfriend.
Judge,
Right? Yes.
just FYI, also there's another open case where I'm sure he's supposed to stay away. 24 PI 003727, an ag assault and reckless conduct where Ms. Jeter is the victim. I think.
Say that PI number again.
Isn't she the victim in this ag assault?
3727?
3727?
Yeah, she is a witness in that case. She might be listed as there might be a no contact in that because she's a witness. She's not the victim in that case. The victim in that case is the defendant's brother.
Okay.
Thank you, boss. All right, so I'll accept this plea as freely and voluntarily given with the understanding of no contact, absolutely no contact, whether she calls you, whatever. If she would happen to, by no chance, happen to pass away, and I find out that you go to the cemetery, I'm gonna put you in jail for 5 years. Am I clear?
Yes, ma'am.
All right, so no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Ms. Zaharia Jeter, no further contact with Ms. Vanessa Jeter, and stay away from 3561 Potomac Terrace in East Point, Georgia. Best of luck to you, sir.
Thank you.
Thank you.
Hey, Freddie, you gonna try to help Ms. Hall out or no? Next, let's go, come on. Ms. Hall. Who's that?
Oh, whatever.
Mr.
I don't care what y'all do.
Oh, I had your approach on that.
We were doing
I was gonna see if it.
He has to engage.
Macomb.
David.
Oh, sorry.
That's why I walked out, because what y'all was saying didn't make sense.
Judge, what's it gotta do?
So,
There's no charge indictment. If you're telling me you indicted,
Oh,
nobody is trying to waive that on the.
Oh, I just have to approve.
What's bring it?
Okay, let me just wait structure, but. I mean, I don't know what y'all can do. But I gotta have something.
Let me just add it real quick.
it's not in Odyssey yet, so, but I'm sure that the December will be -1.
Okay.
I guess we can just give you permission to sign on our behalf.
For Adam right there?
Yeah.
Step out here real quick.
I don't know, like those were, other than that.
And then I asked for the indictment on Davis earlier. I don't know if you typed it in.
Oh, you did.
Oh, and I need gravy.
Mr. Adams, we're back on the record, so are you waiving the fact, Mr. Adams, that the new indictment's gonna end at probably 0-1? Hasn't been uploaded yet, and are you gonna give us permission to sign your name to it?
That's tough, that's tough. Yeah, that's fine.
Yes, okay, okay, thank you, Mr. Adams, you can go back. All right, who's next?
We're gonna approach real quick.
Yes.
This is one I was telling you guys. We got 3 cases, one of which is a home invasion. And we get his ex-girlfriend. And got the shoe. And it ended up in his they're going up his son. And they talk about the ex-girlfriend. That's case on case 2, so aggravated assault a year prior against the same. And then he also has a no insurance and registration. Possession of firearms. State law, they took 30, 1, and so our request. Should I say, do you want, I was just talking, if you want to add? I will. Okay, so their offers for the baby on the basic grant. Right. However, I was asking to get 15, sir, 10 on to wrap up. Well, we put it on 3 numbers. Reason, part of the reason I am actually. During this.
You say.
And she'll see where, is that. My bills here, as a school, still. She's going to leave us, but I mean. She'll see. He's had some surgery. Vein and was not like. Rehab to get the hand. And then he's also due to previous. She started.
Thank you.
So, when he writes, but, that, we've been going back and forth. That's me a trial. I think it's
So now which one do you want back out now?
We're ready on Davis.
Davis? For 38?
Thank you.
For 38, Bostic. Jane Davis.
I don't have a 38. What's his first name?
Shane.
Shane?
2. 4.
Okay.
This is just the paperwork I told you you were gonna sign. Remember we signed you
yeah.
not guilty.
But for
and so-
Matt, we might get to bring him up, so we put this on the record.
Okay, we'll tell him.
Because he's a recidivist, and he goes to trial, that's a whole different
All
situation.
right. Until everybody gets that on copies out.
That's it.
You have to go a long way for your appointment.
I also took that life with the one.
I'm just gonna do, I won't do it.
No.
This is my last name is Schwall'S, so I'm gonna get it done, so don't fall into my face.
Probably that's all I was here, right?
I know you were, when I logged in, I was in Richardson, and I logged in, I saw your name, I was like,
And ready.
I didn't thought we got it early when I seen you. Oh,
So number 3824 SC 005215. Yep, good, that's all.
Ms. Davis, can you please raise your right hand? Do you swear or affirm the testimony she gave in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may go ahead. Please state your true, correct, and legal name.
Shane Davis.
Mr. Davis, you don't have to lean down, as long as you speak up, the microphone will pick you up.
Yes, ma'am.
Okay, thank you.
Mr. Davis, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone to school?
33, and I have my GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
And do you understand you've been charged with aggravated assault and cruelty to children in the third degree?
Yes, ma'am.
Or aggravated assault, family violence, and cruelty to children in the third degree?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defense?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes,
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
so wait.
Mr. Davis, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
Has your attorney advised you of the minimum and maximum sentences to the charges you're pleading?
Yes, ma'am.
For aggravated assault, family violence, the minimum, maximum, minimum is 3 years to serve, the maximum is 20 years to serve. For cruelty to children in the third degree, that being a misdemeanor, the maximum is 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years for the aggravated assault, family violence, and 12 months probation, 3 years probation for aggravated assault, family violence, and 12 months probation for cruelty to children in the third degree to run concurrent to each other, special condition that you have no violent contact with Ms. Corsley, Causey, and that you complete the family violence intervention program. The court does not accept that recommendation. The court can sentence you to the maximum on these charges that can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded in criminal history?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea state?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilt?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or the court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights to enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead in indictment 24 SC 005215 to aggravated assault, family violence, and to cruelty to children in the third degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the constitutionality of this guilty?
Yes, ma'am.
Thanks, Brad. Your Honor, had this case received a trial date and approved Your Honor written down that on August 8, 2023, officers responded to 6670 Buffington Road, that's Atlanta, Georgia, and Fulton County. And when they arrived at the location, they spoke with Ms. Causley. Her first name is Kenyetta, Kenyatta. She told officers that the father of her son, the defendant, came to drop off their son. And when he came to drop off their son, there was a dispute between the two, which turned physical when the defendant smacked her. Well, he actually said he was gonna smack her because she was pissing him off. And at some point during that disagreement, he ended up strangling her. She did call 911. He fled the scene before the police arrived. The warrant was put out and he was arrested on August 23rd, 2023. He does have prior, if Ms. Brown can share his criminal history.
Yeah, Bostic, she can do it. Go, Bostic.
Yeah, I forgot you.
Judge, in regards to the defendant, 5 cycles, he has a prior conviction for aggravated assault, weapon, terroristic threats, and armed robbery out of Clayton in 2015. Nothing further.
Okay. Nothing further from the state. Go ahead, Ms. Courtney.
Your Honor, I just ask that you accept the plea as negotiated. Also, in talking with Mr. Davis, there is some financial hardship, so we are requesting a suspension of any of the probation fees.
How long? The whole time?
If we could, but for at least a year, we would ask.
So we'll suspend a year's worth of fees. No further contact with Kenyatta Causley, CAUSEY, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. You also have to complete that family violence intervention program. I think it's 24 or 26 weeks. I'll accept this plea as freely, voluntarily, and knowing full knowledge of exactly what you're pleading to. Best of luck to you, son.
All right, thank you.
And then you just will talk to them. That would be a great job.
You're gonna bring out Mr. Mack, is that the one you want to put on the record?
Yeah, okay, thank you.
Talk to him now.
Yeah, you'll have to come there.
Twelve and 13. You just gotta put them. I think it's.
He's actually
11,
11,
12,
12, and
13,
13, 13, I think, on the songs.
Yeah.
I said 11 to 13 is Rodriguez Mack, but the ones that was called is for position 12 and 13.
Thank you, Leslie.
I have position 11 and 2.
What's your phone?
I told you that I was gonna ask her about the non-negotiated, and she specifically just say ready for trial. And so they want to bring you out just to put it on the record, the offer. And you're also recidivist, so they'll explain that as well. But I'll definitely come. I'm gonna be on vacation next week, but I'll come see you at the jail when I get back. And then we'll talk some more. Okay?
This position 11, 12, and 13. All right.
Oh, Your Honor, I did, the state just want to put on the record the offer, for 24 SC 005237. Count 1, home invasion, the state's offer 20 years to serve. For count 2, aggravated assault, the state's offer is 10 years. 10. On count 2, the state's offer 10 years probation to run consecutive to count 1. And then count 3, aggravated assault, count 4, aggravated assault, both the same 10 years probation to run consecutive to count 1, but concurrent to each other. Possession during 5 years, probation suspended to run consecutive to count 1. And then possession of firearm during 5 convicted felon is 10 years to serve to run concurrent to count 1. In the other case that I had 24 SC 0038584, the state's recommendation is 5 years to serve, on that case. And the third case, that the defendant has is indictment number 23 SC 190577. The possession of firearm during the commission of felony, 5 years to consecutive. And 88, all right, he's gonna put his off on the record for that particular case.
And the state's recommendation would be the 10 years to serve and a not cross for the expired tag and no insurance.
So in total, Your Honor, the defendant is looking at 90 years. The state did file a recidivist on this defendant, so at trial, and that's a recidivist on receipt. So under trial, he will be facing the 90 years.
All right.
Opposed to, for the main case, if we do a global offer, it's 30 to 31.
Anything, Ms. Carter?
No.
All right, thank you. Best of luck to you, Mr. Mack. What's that?
Is there an expiration on this offer is what I wanted to
Oh, no,
know, number
today.
one.
That was,
Yeah, he started down today.
No, is there an expiration on the offer?
to 30, 20.
Yes.
That's today.
Today, so that offer will no longer be.
Right, that's all I'm gonna put on
Okay.
there.
And I know you're leaving us,
Mhm.
and said, so you go. How long will it take for the next person to get up to speed to be ready to try this?
I think it's a pretty straightforward case for the state. So whenever you wanna put it on, as long as it's not Monday. The next trial calendar will be fine. We take it out.
Well, it's McGirt, so they just need 30 days.
Yeah.
Next.
McGirt. Use the indictment for McGirt is called.
Yeah, 34.
Oh. Number 34. 34, Boston.
Ms. Valley.
How to spell the last name?
McGirt Karon.
Ms. McGirt, can you please raise your right hand? Do you swear or affirm the testimony she gave in the matter current before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, may Lord in here. Please state your true, correct, and legal name.
Karan Dante McGirt,
You can spell.
Donte.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone to school?
34 and technical college.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with aggravated assault, family violence, and battery family violence?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty on those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her service?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So wait.
Ms. McGirt, have you been arrested on these charges?
Yes, ma'am.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
No.
No, ma'am.
Has your attorney advised you on the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
For aggravated assault, family violence, a minimum and maximum of 3 years to 20 years to serve, and for battery family violence. Yeah, all right, 1 second, ma'am. You go. For aggravated assault, family violence, is 3 to 20 years to serve, and for battery family violence, is 1 to 5 years to serve. Do you understand?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to The court may offer a 5 years probation for both counts to run concurrent to each other, special condition that you have no contact with the victim in this case, Ms. McGrick, and complete the family violence intervention program. The court does not accept that recommendation, though. The court considers you to the maximum on these charges and can run those sentences consecutively or not gonna know. You understand?
Yes, ma'am.
You understand this is a guilty plea, which is permanently reported on your criminal history.
Yes, ma'am.
You understand if you're currently on probation or parole, your probation or parole may be revoked based on your incident guilty plea check.
Yes, ma'am.
You understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
You understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would. And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand about pleading guilty to a felony? If you receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering the plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes,
the right
ma'am.
to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel offered by you as a court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea when you're in fact guilty?
Yes, ma'am.
In indictment 24 SC 005100, how do you plead to the charges of aggravated assault, family violence, and battery family violence?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have 30 days to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years to stay for a felony charge to file a habeas corpus petition challenging the voluntariness of the constitutionality of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, Ms. Boston can give his criminal history pre-trial. Yes.
Judge, in regards to Mr. McGritt, he has 11 cycles left. There's a fugitive from justice arrest in 23, currently on probation out of Chatham, 8/6/19 for aggravated battery and another charge, 7 years confinement, 13 years probation. There's about 3 other felonies, false statements and battery in 2017 out of Chatham, criminal use of an article on ID and theft by receiver in 2012 and a prior burglary. Nothing further.
Your Honor, had this case considered trial, the state would prove beyond a reasonable doubt that on June 18th, 2023, at 231 Scapel Terrace in Atlanta, Georgia, Fulton County, officers reported to their location and spoke with the victim in this case, Ms. Karen McGritt. She's in court today, Your Honor. This is the wife of the defendant. She reported, Ms. The chair of McGritt, I'm sorry. She's in the courtroom today, and she told officers when they reported to the address that she had gotten into an altercation with the defendant. He put her in a headlock. He started to strangle her to the point that she could not breathe. At some point, he bit her. They both ended up falling while he had her in a headlock. When he bit her on her nose. She still has a scar from that bite mark now today. When officers arrived, they were able to see visible injuries to the victim. The defendant was charged accordingly, and it is all from the state, and the victim at the time does not want to make a statement.
She wants no further contact with him?
No further contact.
Go ahead, Ms. Clark.
We just ask that you accept the plea as negotiated. In addition, Mr. McGirt did want me to ask the court to consider suspending the probation early, so long as he remains out of trouble. We would like to ask for after 3 years if the court would consider suspending the last 2 years, should he stay out of trouble and have completed the family violence intervention program. There's no issue with Mr. McGirt having any sort of contact. He hasn't had contact with her at all since this incident. He currently lives in Savannah, Georgia, so there's no reason for him to be here to have any sort of contact.
So, Your Honor, based on his history, the state would object to him having early termination for probation. This defendant, he was already told, he already had one case against the same victim when he picked up this case. And he already had other aggravated assaults and aggravated battery cases, so we would object to early termination at this time.
No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with LACHARA, McGirt, MCGRT. Fulton County, unless you're here for court or to see your lawyer, another reason you come to Fulton County, right?
Yes, ma'am.
All right, stay out of Fulton County. Also, do you need to look at the probation fees waived at first or not?
I pay it.
All right, we'll waive 6 months, huh? You'll pay it?
I pay it.
Ms. Carter was trying to help me out, but okay, I'm not gonna waive.
We're gonna, just to waive some
She
probation
can
fees off
petition
the
if you
top.
want to terminate it, but yeah, based on his record right now, I'm not gonna do it. Plus, it's a work to go previously.
And if we could just put Ms. McGirt's maiden name on the record, because I don't think they are actually married, but I don't think they'll remain married just in
Cardwell,
case.
CARDWELL. Are you divorced now?
My court date is on the 6th.
I don't know if they're married.
It's a publication.
There's a question of whether or not they're married.
I don't think that matters.
That's what I just requested that they put the maiden name on there. They won't.
Come from divorce, you have to have contact.
Yeah, you have to talk to probation.
Best of luck to you, sir. Next.
I've got,
Horses been on.
yes.
No, work is on Zoom.
Even though he on Zoom.
Yeah, okay. And I mean, it was him and Banks, they both on Zoom. Horsley, Hosley, I'm sorry, it's position 6.
Position 6, Boston.
Can you turn on your microphone, Mr.
Name.
Mosley?
Who's 6?
Yes, ma'am.
Hello.
We don't need this tomorrow, we're dealing with Mr. Jose.
And this is gonna be under first offender. Okay.
Can you hear me?
Yes, we can. Thank you. Thank you for your patience today, too.
Yes, ma'am.
I have 4. We have one, I have 1, 2, I have 3 inmates back.
How many do you have on this?
I've got Baines.
With Ms. Hall?
None.
No, we took ours earlier.
Yeah, we took ours already.
You with McCombs?
Since,
He's
Sorry, myself,
Todd is on waiting, she's been waiting.
restless. Can we get the inmates really quickly?
Online.
Sorry, Mr. Wilson.
You with McCombs on y'all?
No, Derwood is here, Ms. Hodge is on Zoom, the prosecutor.
Let's just get the inmates really quick. What's your name? Saunders.
We're just stipulating.
Which one?
Saunders. Give me 1 second, Mr. Hoser.
Sorry, yeah, sorry, Mr. Hopefully, we got some inmates back here that need to go back to.
Yes, ma'am.
Officer Brown, Dunham, Sands, Saunders.
Just got up. I'm gonna get my back there acting a fool.
Put my head right. I'm ready.
Judge can hear it, everybody out here can hear it. You want to pick up new charges?
That one.
You know what position? We know you like it.
This is gonna be position 2 and 3.
Don't know.
Under probation revocation.
We should try not to pick up new charges.
Oh,
while you're
probation
back there.
revocation?
Yes,
Don't make no sense.
Hey, John, why that second spell?
Or
Should happen.
Yeah, that's true. I get that.
Ms. Carter, do you have any real probations for her?
I gave them to you. I just gave you Hosley. I don't have Baines.
You need things? Yeah, she can try to put on that.
No, I have things.
And you can, she's gonna sign it and come back.
I need to write down the, what is it, 16, what is the battery statute?
Oh, no, I'm just gonna sign. You can do it.
Okay. Someone else is gonna.
No, I'm gonna do it. I'm just gonna get on some.
Oh,
This is just a probation revocation for Saunders. Ms. Carter.
Yes, we are stipulating to the, we're stipulating to the revocation. My understanding that the recommendation from probation is to revoke 6 months. Mr. Saunders is also going to be assigned a mental health probation officer. He's also going to have to finish the requirements of his probation upon his release. And there are some time limits that I'll let.
I just put the docket numbers on file, on record. I'm not sure there are. It's 23 SC 186662, 23 SC 191502. Both cases, the violation is pretty much the same. The two violations of criminal law. On the case ending in 662, there were 2 additional technical violations that were not fulfilled, and there are listed as failure to complete community service and enter and complete anger management. The 2 arrests that are listed is one is enter auto, and the other is a bus or rail vehicle hijacking in Fulton County. I am recommending to revoke 6 months, reinstate the balance, continue with the attendance and completion of the day reporting center. The defendant signed a waiver to enter and complete that reporting center back in May 15th last year. Take any medications prescribed prescribed by a physician or for any emotional or mental health problems, must be assigned a mental health officer. And additionally, for the case ending in 662, to complete 10 hours of community service within 30 days of release, and to also enroll in anger management within 30 days of. And of course, that.
Yeah.
And we only have one request, is that we get credit for the 30 days that he's currently been in.
I'm unable to put credit on the revocation orders. We have a new revocation order. Only thing I can put is as determined by this custodian.
Oh, yeah, we can ask it to this. Okay.
A what? What does that mean?
It's gonna be determined by the custodian, so it's gonna be determined by.
Who's next?
Okay. So how many days I had it?
6 months.
Just a whole 6 months.
They make it each the 30.
Which one's next?
Mr. Wolfley?
Add more,
He's-
position 1,
Oh.
motion, Kevin.
Add more. Councilor Ewing. Add more.
Yeah.
Okay.
I didn't know what it is.
No, the one from the other day.
Oh,
we
okay.
dealt with. Oh, yeah.
You remember it now?
Yes, okay.
I'm so glad it's my last day, man.
Oh, you guys gotta get us down for sure.
Yeah,
that's right.
At Ward 22 SC 18521. Here it goes, just a one sheeter. It was a one sheeter, we had to, he'll give you one.
It's a one sheet motions coming.
Yeah, we had to.
We're doing it correct, that's it, it's based on this.
Yes, that's all we're trying to do.
Add more, position 1 on the motion, Kevin.
This is
Go ahead.
Mr. Atmore. I was making sure Ms. Saunders is ready. Okay. This is Mr. Atmore. I filed a motion to correct his sentence. On January 31st, he was in front of Your Honor on a probation violation. There were 4 allegations. We stipulated to 3, that he left the state and didn't complete 2 classes. Each class was a separate list. In addition, there was an allegation on the order that he allegedly had violent contact with a Ms. Curtis. Ms. Curtis was present on Zoom but couldn't be heard. She sent an email to the court, if you recall, saying that she had made up the violent contact to help her custody case against Mr. Atmore. And so the order that was done by the court, and he was revoked for 1 year, day for day, according to the order. The order reads that he had contact with Sade Curtis, that he violated no contact with Ms. Curtis, no contact is not a violation of his probation. And so I'm asking the court to find that there was no, that is not a violation, to remove that from the order. Also, I'm asking the court to give him credit for the time that he spent on probation from 8/31/24 until the present, which is approximately 177 days. So just asking to correct those two issues on the sentence.
Okay.
That's what I said.
And I think it was put in there, not, she alleged it was violent contact, but sure, or did we talk, you gonna break up there, right?
Yes, ma'am.
They're no longer having any contact. And Your Honor, I also wanted to remind the court that although it's not, he did not spend it related to this case, Mr. Atmore spent another 586 days in the Fulton County Jail. He was arrested January 24th of 2024. And that case was subsequently dismissed. So even though it wasn't related to this case, Mr. Atmore has spent approximately 700 days or almost 800 days in the Fulton County Jail. And so I would hope that the court would be willing to maybe even consider commuting his entire sentence to time served at this point.
So I'm hearing that you're asking for credit to be granted to 2024. Probation didn't even start to 2026. I mean, let me see.
I think he was incarcerated, so he wasn't able to actually start it till 2020.
Correct. He was sentenced in November 28th of 2023, but he didn't actually start until August 31st of 2024.
Well, at this moment, the revocation that was is put in, and it's showing me that his probation is not going to start back until 2026. So I don't see those numbers now due to that revocation being put in. And what was put on the transcript is what was put on the order.
Right. So, Your Honor, the state would just take the position that with regard to the transcript, if you look at page 12, it does reference the date of 12/23/24 as when he went into Fulton. And then on page 15, Mr. Norman again states, and credit for the 40 days that he's been in. And if he did the 40 days, that's from January 31st, which is the date that we were in court, to the 12/23/24.
And again, that is when he went into the Fulton County Jail.
Because the credit for his probation time before he got arrested.
Correct, Your Honor. And I believe that is due pursuant to 42-838, Section C, which states that time served on probation shall be considered as time served on a revocation.
Right, and he was in custody in a different county for different violent charges, was released on the streets, then got picked up on our probation violation warrant. We can't grant time for him being on the streets. The time that he's on the streets, walking around, serving probation time. We can't give him double time just because he got arrested on the warrant.
Right. So he was picked up on charges in Cobb County.
And the court
If that's the
maintains.
case, nobody would have a probation revocation. Everybody just have credit for time served.
And the court maintains jurisdiction over these revocations. And so I think you can correct the no contact provision that's listed on the order, as well as re-sentence him as you see fit.
So you correct that as it was alleged that there was violent contact.
Correct. We can.
I'm chagrin, everybody else is quiet about it, just to get.
Okay, right, I have to go off of what's in black and white. That was on the report, and that's filed and addressed. I mean, something else needs to be filed stating that she didn't, it was not violent contact. If that's in place, then I can take it into consideration, but if not, I can just go off of what she just says right here. And oh, it wasn't violent contact. I mean, anything can happen, could have been some type of influencing the witness. I don't know.
And as I recall, she was here, Your Honor. We just couldn't hear her, so she sent an email.
She also signed off. That was the one who you repeatedly asked her. She signed off, turned off her camera, and then disappeared. And then when you kept on asking her, and then you said it's clear that she doesn't want to even testify.
That's not exactly what happened, Your Honor. She signed off and then signed back on. She disconnected and then came back.
If she here today, this is a motion hearing. Is she here today?
When'd you break up with her, Trevor?
Me and her, when I was released, we actually wasn't in a relationship. My daughter was born when I was incarcerated. So the whole thing about me going to New York for 3 days and everything was me coming home, trying to get my family right and everything and stuff like that. And she's on her own journey with CPS and stuff. So one of the CPS workers or whatnot told her that.
No, she just wants to know if you guys broke up.
Oh, no, I'm not.
His girlfriend is actually, I think, present or was present earlier. So so he is not with Miss Carter or Curtis anymore.
All right, so what we need to do to, Ms. Woods, like, we need to correct, right, that it was alleged violent contact, but it was contact, right, Ms. Brown?
If it's, from what I heard, everything was stipulated. Stipulated means you agree to all the allegations in the petition.
And if we look
now we're coming back and saying it's not stipulated, please remove the verbiage.
No, and if we go back to the transcript, we stipulated to 3 things, and I specifically said we were not stipulating because we had a witness who was going to testify about the violent contact. So I stipulated to 3.
Why don't we just do this and give him because you've been in there since December?
All in all, he's been in there since January 24th, 2023, essentially until now.
No, I'm talking about when he got arrested, picked up on this one.
Oh, and this one, he got picked up December 23rd, 2024.
Can I just have another chance?
That's what we're doing right now.
Can I read my letter to her?
All right, well, just, he can just serve the 90 days and then it'll be done. How about that?
Thank you, Your Honor.
Take it out in a couple of weeks.
Thank you so much, Your Honor.
Okay.
McComb, position number 4 on the plea and arraignment calendars.
Report, Boston.
Yeah, Ms. Hodge, yep, she has been patiently waiting online
Sherwood McComb?
with her wonderful glasses.
Sherwood McComb, is that right?
Yes, Your Honor.
All right.
Is that the last defendant?
And may I ask Ms. Hodge if the court can sign her name on the indictment?
Yes, please.
Your Honor, one question. So you say it's gonna be 90 days and you're gonna be released. Is he going back to probation or not?
It was 90 days, I think, in return to probation.
Yeah, return.
So the order's gonna come from the court. No.
I'll prepare an order and email it to you if the court would like, or.
Absolutely. Thank you.
Yeah. We keep it here late, we're here late. We're all in trouble.
I mean, y'all have gone, I'll be at 8 o'clock.
I'm not going to stay here by yourself.
Oh, I got work to do. Fine,
All right, so that's on the side, you, give her permission to sign your name. And
Contact orders team between me and my daughter.
It's gonna have to
Too late.
be
Yes, Your Honor.
Okay.
no violent contact because and relate whatever.
All right, number
CPS.
4, 24 SC 005-199, Durwood, McComb. All right, go ahead. Yvonne.
Thank you, Your Honor. This is a negotiated plea for the court's consideration. The defendant is charged with 1 count of cruelty to children in the 1st degree. Mr. McComb, please raise your right hand. Do you swear or affirm that the testimony you shall provide the court in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, please lower your hand. I'm going to ask you some questions. Please answer yes or no. Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication you normally take that you have not been given today?
No, ma'am.
How old are you?
21 years of age.
And how far have you gone in school?
Graduated.
High school or college or?
High school diploma.
Okay, so you are able to read, write, and understand the English language. Have you had a chance to review the indictment with your attorney?
Yes, ma'am.
Do you understand you're charged with 1 count of cruelty to children in the 1st degree?
Yes, ma'am.
Do you understand that this sentence, the sentence for this charge has a range of a minimum of 5 years, a maximum of 20 years in custody.
Yes, ma'am.
Do you understand you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Do you understand that the recommendation for the court's consideration will be 8 years to serve 2 years, credit for the time that you have served, balance on probation? But the court does not have to accept this recommendation and can impose the maximum punishment allowed by law, which again is 20 years in custody.
And I'm sorry, may I just correct that it was commuted to time served?
Yes, commuted to time served.
Yes, ma'am.
Balance on probation. And there are some terms of probation that the state would ask for that have not been discussed with your attorney when I was there earlier. Attorney, Attorney Norman, the state is asking for parenting classes and no violent contact with the juvenile victim. I am not sure if there is a defects plan currently in place. There was at the time of this incident, but if there still is, to follow any defects plans.
And that's fine. I was gonna ask for no violent contact and contact as directed by defects.
Okay, thank you. Mr. McComb, do you understand that this plea may be used to enhance sentencing on other pleas in this jurisdiction or any other jurisdictions?
Yes, ma'am.
Have you had a chance to discuss this recommendation with your attorney?
Yes, ma'am.
Okay. And do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of this governmental unit or any unit, that means this jurisdiction or any jurisdiction, without being subject to revocation for the balance of the sentence? Which means if you have 6 years on probation and you violate probation, you risk being placed in custody again for the remainder of that time.
Yes, ma'am.
Do you understand that you are not allowed to possess or use firearms while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years?
Yes, ma'am.
Do you understand you waive any and all defenses, including any mental health defenses, by entering a plea today?
May you repeat that?
That you waive any and all defenses that you may have if this case were to go to trial, including any mental health defenses?
Yes, ma'am.
And by pleading guilty, you are giving up the following rights. Do you understand that you are giving up the right to a trial by jury?
Yes, ma'am.
Do you understand you're giving up the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand you're giving up the right to confront witnesses called against you?
Yes, ma'am.
Do you understand you're giving up the right to assistance of counsel, either a court-appointed attorney or a private attorney, if you were to go to trial?
Yes, ma'am.
Do you understand you're giving up the right to the presumption of innocence?
Yes, ma'am.
Do you understand you're giving up the right to testify on your own behalf and present other evidence?
Yes, ma'am.
Do you understand you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes, ma'am.
Do you understand you're giving up the right to prove the charges beyond a reasonable doubt?
Yes, ma'am.
And do you understand you're giving up the right to appeal if convicted of these charges after trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to give up these rights and plead guilty today?
No, ma'am.
Do you understand you have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand you have only 4 years from today to file a petition called a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Do you understand that you have 30 days from today to withdraw your guilty plea?
Yes, ma'am.
Thank you. No further questions. Your Honor, had this case gone to trial, the state expects that the evidence would have shown that on July 16th of 2024, the Sandy Springs Police Department was called and responded to a call at, I believe it was CHOA. Yes, the Children's Hospital of Atlanta. At that time, the victim, because she's a juvenile, I will refer to her as LM. She was 13 months old at the time. She was in the hospital because she had been taken to the hospital and had a fracture in her skull. Her parents reported that she had fallen, and that's what the cause of the fracture was. She was being treated for that when a nurse observed that the defendant was in the room with her, pushing her head down into the mattress in an aggressive manner. Police were called to the scene, and he was arrested for that charge. The recommendation that was, first let me say, I do not know if anyone was charged for the initial injury that the child sustained that caused her to be at the hospital. But that case, if there is a case, and I'm not sure if there is not being resolved by this plea here. This plea is only for the purposes of the action of the defendant being seen grabbing the child by the head, which already had an injury, and pushing her head into the mattress of the hospital bed. This recommendation was previously offered to the defendant in November of last year by the previous ADA assigned to the case. And today that offer did expire. So if we had moved forward, the state's intention was to withdraw that offer. In terms of his criminal history, I will defer to probation.
Judge, 2 cycles. It appears he has an open case in Worth County for burglary from 1/13/24 arrest. Nothing further.
And Your Honor, obviously, as always, we don't completely agree with the state's recitation of facts. However, I'd ask that the court accept the recommended sentence with one exception. Mr. McComb does not have any felony convictions and never taken advantage of a first offender. I would ask that he be treated as a first offender. In this case, he will have, plenty of time on probation to prove to the court that he is not a danger to society or anything. I also want to point out that this entire episode, according to the witness, lasted 10 seconds. There was no immediate report made. It was made the next morning. And so I would just ask you to accept it and treat him as a first offender. And then finally, because he does have a child, I'd ask that if he's allowed to be treated as a first offender, that we also seal his record pursuant to the statute during the term of his probation so that he can work in.
Has he legitimated this child?
I don't believe at this point. He is on the birth certificate, but as far as going through the legitimation process in the family court, he's not done that.
I do have a legitimation motion sent out to the Worth County Clerk of Courts, and I plan on getting legitimized through DFAX, who has recently. Yes, ma'am.
Have you been paying child support?
No, ma'am. No, Your
Or have
Honor.
you been taking care of the child?
Yes, Your Honor.
No. How have you been? He said you take.
Well, they were living together. It was him and the mother lived together with the child.
Are you in contact with one another now? You and the mother?
No, Your Honor.
And they're not allowed to have contact right now because of the case. Because of the other case, yeah.
All right, so it'll be, yeah. I'll agree with what the state said. I'll take that. And no drugs, no alcohol, no weapons, no replicas of weapons. Yeah, I say parenting class just seems like, that's only like 4 hours, isn't it, Ms. Hodge?
Well, there are 8 and 12 hour classes. It's my understanding that he would be evaluated and probation would determine whether and which amount of classes that he would take. DFAX will probably also put something in place and they may overlap, but I'm not sure.
Yeah, so Ms. Brown, you guys would handle that? Or I guess it'd be transferred to North County, right?
Yeah, it would be a referral.
Okay, and any visitation or time for this child will be governed by whatever the juvenile court's doing in Worth County, right?
Yes, Your Honor.
In Worth County, because I'm not gonna, yeah, so they'll control any visitation, any time with the child alone and things like that.
Yes, Your Honor.
So I'll leave that up to them. I guess you just let the state know here what you're doing.
Well, Your Honor, if that's the case, can a term of probation be that visitation be determined by Worth County?
Right, yeah.
Okay.
Yes. So, yeah, the work county doing because I'm sure they have a plan that's gonna work. Okay?
Correct.
So make sure you follow that and take care of that. Best of luck to you, sir.
Your Honor, will you treat him as a first offender?
Ms. Hodge?
I thought I heard probation say he has is that pending or is that?
Yes, it's an open case, should be out of Worth. It's from a 1/13/24 arrest.
Oh, okay. I mean, if he qualifies.
He qualified. That case is not a conviction. There's been no finding of adjudication of guilt in that case.
He wants to seal it now.
Oh, no.
Yes.
No, the state would object to that, that it be sealed right now. We would ask that he have to follow all the recommendations and successfully complete probation before his record can be sealed.
And I would just ask if we could, I don't mind him doing the conditions, but if we could come back once he's done the parenting classes and see if the court would seal it at that point. Thank you, Your Honor.
Well, can I also let him know, Your Honor, I want to make sure that he understands that if he violates the terms of his first offender probation or commit any new offenses while on probation, his first offender status could be revoked. He could be adjudicated and could be resentenced up to the maximum sentence for this indictment. Do you understand that?
Yes, ma'am.
Okay.
All right, thank you. Best of luck, you sir.
Thank you, Your Honor.
Position number 5 on the plea and arraignment calendar for Rail.
And Your Honor, that concludes my business. May I be excused?
Ma'am, thank you for being
Okay.
patient.
Thank you. Have a great
Farrell's
weekend,
first
everyone.
name?
It's Joseph.
8 years. Over 2 needed to die. So
Got it.
Farrell?
Ferrell, yes. First name Joseph.
finally contact with the like.
Who's on this? Is you, Mr. Brown, or who?
Okay. Sorry, Your Honor, this is Mr. Farrell. There was an. I don't know where's the press. Are you good? Yeah. Oh, good. Oh, okay. There was an offer made for Mr. Farrell. I wanted to put on the record. My understanding at this point is he does not want to take advantage of it. But I did want to put on the record so that he has heard it and can tell the court.
Mr. Brown, what's that offer?
The offer is 10 to serve 7. And just to put it on the record, Your Honor, the issue, or not the issue, but rather the something for him to contemplate is that if this offer is only for today, if we were to have to move forward to trial, we would be looking at re-indicting the matter to add 2 additional armed robbery charges, and that maximum would be then 30 years mandatory. So just putting out there.
Right, and the reason I want this on the record is that I explained to my client that armed robbery carries a statutory minimum of 10 years. And unless the state, by agreement, agrees to sentence him below that, which they're willing to do in this case today, they're willing to allow him to plead to 10 to only serve 7 with credit for the time he served. And understanding that, Mr. Farrell, and hearing the prosecutor put on the record that they're going to add, since there were 3 people present, they're going to add 2 more counts of armed robbery. Are you still wanting to?
What's his history look like?
His is not on the drive. Let me look again. Joseph Farrell, Farrell.
F.E.
F.E. Aha.
There's no violent history. Let me find it. I had it printed.
There it is. He currently has 2 holds, 1 out of Cumming for ID theft, 1 for probation violation out of Milledgeville. He only has 1 other arrest. It's a forgery in the 4th sentence in 2023. So he's on probation for 3 years out of Baldwin County.
Thank you.
Yes, so he has no violent history.
So that's it, Mr. Farrell. When you walk back in there, offers off the table.
Do you understand what the offer is?
Will there be more offers?
It's gonna go up. The next offer will be higher.
Next offer is going to trial. When's the trial calendar, Ms. Wood?
This is actually a trial calendar. I understand that Mr. Brown just said that the state was going to re-indict to add.
Oh, so it'll be pushed out.
Well, that's what, yes, unless I call it in Monday, they won't have time to.
Get done today.
So we have the next trial calendar.
No, it's on this calendar.
No,
I'm
not
not
they
coming on
re,
this calendar.
they reindicted it.
Maybe not.
Yeah. Right, what you wanna do, sir?
You know what my recommendation is, but it's entirely up to you.
There's like, is there any chance of tomorrow?
I think it's any better.
On the
It's,
library?
no, it's a total of 15-7. 10-7 is the armed robbery because it has a possession of firearm, which would be consecutive. So that's going to be the consecutive 5 years. But that would be probated. So.
Oh, this is pursuant to that subsection, section E.
When I go to trial.
While he think about it, can I take my pleas?
So anytime.
Seems like he's thinking about it. Can me and Carter take our pleas?
He's not pleading to armed robbery, right?
He's scared.
What is he, what is he getting?
It will be reduced to criminal attempt to commit armed robbery.
Oh, okay, so is that, okay. Is that
Yeah, so that's how you get up.
Well, yeah, I'm not. Hold on one second.
All right, Mr. Hosley, how about you go back there and let's go do these two on there, and then that's it. You got to go.
Do what?
We have one more person in custody, I think.
What's the last one? Okay.
Yeah, no, that, yeah.
Yeah,
Let's do
just-
the bond hearing on.
Can you give us a minute and recall the
Yeah,
case?
yeah,
All right, 1 minute, that's it, they're gonna get them out of here.
Yeah.
And then,
Okay, you're going back there in the back, talk to him, okay.
so we're taking Mr. Hosley. Thank you, Mr. Hosley, for being the probation once again.
All right, y'all. You still got, I gave it back to you, right?
Yeah, I think, I didn't,
I forgot what number.
I got Hosley, I mean Baines. I gave you back Baines.
you gave me bangs.
Okay. Hosley, number 6 on the final plea and trial calendar. Mm-mm.
No, we stopped, so we can get rid of that.
Yeah. I think you had set it up.
Yes. 23 SC 18559.
Then the deputy started talking about the inmates.
What was the one we didn't send it? It was Mars.
Yeah.
Yeah.
It's
All right.
All right,
Mr.
I'm ready, Mr. Hosley.
Mr. Hosley, can you hear me?
Yes, ma'am.
All right. Everybody ready?
Yes.
All right. Ms. Hosley, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
William Tavares Hosley.
Can you repeat it again, Mr. Hosley?
William
Oh.
Tavares. I'm
Can you
sorry.
spell your middle name?
Tavaris.
Got it. Okay. And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
I take my my mental health medicine, but that's about it.
Did you take it today?
Yes, ma'am. I took it this morning.
Will that affect your ability to understand what's going on today?
No, ma'am.
Okay. How old are you and how far have you gone to school?
Graduated high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
And do you understand that you've been charged with aggravated assault, family violence, theft by taking, cruelty to children in the 3rd degree, obstructing or hindering a person from making an emergency phone call?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes,
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
so waived.
Mr. Jose, have you been arrested on these charges?
Ma'am?
Have you been arrested on these charges?
Yes, ma'am.
Okay. I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Okay. Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
For aggravated assault, family violence, the minimum is 3 years, the maximum is 20 years to serve. For the 3 remaining counts, theft by taking, cruelty to children in 3rd degree, and obstructing or hindering a person from making an emergency phone call, those are all misdemeanors. The maximum is 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 3 years probation for the aggravated assault, family violence, 12 months probation for the remaining 3 misdemeanor charges to run concurrent to each other. Special condition that you have no contact with Zanicia, Zanieshia, Cloud, and complete the family violence intervention program, but the court does not have to accept that recommendation. The court can sentence you to the maximum on these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pleaded guilty or no longer contendere to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced for up to the max of each charge in this indictment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by answering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that if you went to trial? Do you understand by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to answer a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 23 SC 185599, how do you plead to the charges of aggravated assault, family violence, theft by taking, cruelty to children in 3rd degree, and obstructing or hindering a person from making an emergency phone call?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge, 4 years from today for a felony charge to file a habeas corpus petition challenging the constitutionality of this guilty plea?
Yes, ma'am.
Thank you, Mr. Hosley. Your Honor, the state is unaware of any prior felony convictions by the defendant, and had we proceeded to trial, the state would have proven beyond a reasonable doubt that on June the 21st, 2020, at 6127 Highway 29, that is in Atlanta, Georgia, Fulton County. That's Union City, Georgia, Fulton County. Officers arrived to their location and they spoke with Ms. Cloud, the victim in this case. She told officers that her boyfriend, the defendant, had physically assaulted her, and when she was trying to call 911, he took her phone, he left the apartment. He ended up coming back to the apartment. When he took her phone and left the apartment, he also took their baby as well. They share a child together. He took the baby, left the apartment, came back, gave her back the baby, but kept her phone. At some point, during the physical altercation, he got on top of her, and he scratched her face. She did run over to the neighbors to call for help. She did decline medical attention, but warrants were taken out for Mr. Hosley. He was gone when the officers arrived, so he was not arrested on scene. I have spoken with Ms. Cloud. Ms. Cloud just wishes for this case to be over. She doesn't want any contact with the defendant. If he chooses to have contact with his child, he'll have to go through the legitimization process. That is all from the state.
Ms. Carter?
Your Honor, on behalf of Mr. Baines, we'd like to request an early termination of the probation after.
Mr. Hosley?
Sorry.
That's okay.
For Mr. Hosley. I apologize, Mr. Hosley. On behalf of Mr. Hosley, we'd like to request that the probation terminate after 2 years, so long as he's able to complete the family violence intervention program and has no further contact with the law. We'd also like to ask the court to consider waiving all the probation fees for the entire time he's on probation. Mr. Hosley is currently confined to a wheelchair. He is receiving I think it's SSD, Social Security Disability. So any funds that he does have should be going to his child support. And lastly, we also did discuss possibly sealing his record until he completes the first offender. So sealing the record at the top half of the probation until he completes the first offender.
No, nothing further from the state. Your Honor, I'll leave it to your discretion as far as the probation.
So, as far as the child money syndrome, I think it was, that go through, take the legitimation of the child support papers, take it to Social Security, and they'll handle that. So they'll pay it if you don't have to. But we'll waive your fees, no further contact with Ms. Cloud. For these here, right? And no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Any contact with the minor child will be through any legitimation of custody action that you have.
You said what?
Any visitation with the child will be based on any sort of legitimation or custody action, because I can't order him to have visits when he has no rights. So, but just because you don't have rights to visit the child doesn't mean you don't need to pay child support. They're not linked together, so you need to pay some child support for the child, right? So we'll accept this plea as freely, voluntarily, and fully informed, and I will take it into consideration as a negotiated plea and do the first offender.
Will you allow, I can do an order for the court to seal. Yes.
Okay.
You got the family violence intervention program, right?
Yeah, in the family violence intervention program. So that's like 24, 26-week class. So don't wait till the last minute.
Felony probation?
Yes.
Yes. felony probation.
Do I need to log on, get his address and information?
You just put the address on the line, but. So do you have access to a keyboard right now?
Yes, ma'am.
Right, you go over to the chat. See what the chat is?
Yes, ma'am.
All right, and you need him to put in there?
Address, phone number. He lives in Georgia, right?
Yeah, that's it. So address, phone number, email.
Address, phone number, what email?
Address, phone number, and email, and I'll give it to the probation officer who will reach out to you.
Does this
Okay,
make
you need my
sense?
address, phone number?
Your address, your phone number, and your email.
Okay, 106.
Put it in the chat.
Can I just get a zip code?
Oh, I'm sorry.
The zip code. It's Brian, then I see you, that's in
I think I have it.
Carter, you have all of, I know there was a.
I did do a change of address, so.
You just did his phone number, and email, right? I see the address change.
Yeah, so
Do you have the other info you can give her?
Mr. Hosley's phone number is,
Email it to my.
She said address, email, phone number.
30286. Thomas.
we've got it. I'll email probation, both your phone number and your father's phone number. I'll email your address and both your email and your father's email. I'll make sure probation has that. So probation is going to follow up with you about how you're going to report to probation, okay?
Thank you, Ms. Carter. Did he get first offender?
We did do the first offender, and we're also going to seal it as well. Remember, I talked to you guys about that.
So whoever else is talking, don't talk because it won't make the record clear, okay? Thank you, Mr. Hosley. Best of luck to you.
Yes, ma'am. Thank you.
Thank you.
Thank you.
All right.
Can we do Mr. Baines?
Yes, sir. Have a good day.
Mr.
Okay.
What? I was talking to you. I was like 5 minutes.
What's he gonna do, Mr. Norman?
Oh, we're entering the plea, Your Honor. We're just writing down.
Why they still write down what they want? Can we do Baines?
Still working on it?
Yeah, they over there looking at the codes.
We're ready for Mr. Baines.
Mr. Baines, can you please raise your right hand?
I'm not ready.
And if I could just ask Mr. Baines one quick question. Did you want to use your first offender today? You do have the benefit of using that before the court today, and that would, upon your completion of the probation, it will seal your record. But if you use it, you lose it. So you won't be able to use it. If you have a felony in your future, you're not going to have that available to you.
What happened if I don't, what's gonna happen to my record if I don't seal it? And will I be able to get it expunged?
I mean, you can still go through the expungement process, yeah.
Would that, if I seal it through the expungement process, would it count as my first offender?
No.
Then I'm not gonna use my first offender.
Okay, we're ready to go forward. Sorry.
Which Baines is this?
Mr. Baines, can you?
This is Christopher
Christopher Baines.
Yes, position 48.
You got a criminal history already, Bostic?
No.
Not you, Bostic. Your name's not Bostic.
Your name's not Bostic. Mr. Baines, 2 cycles.
I didn't hear the last name.
That's okay, sir. Just one prior arrest for disorderly conduct in the OIG.
Okay. Thank you, Bostic.
What's the last thing she said? I'm sorry.
Illinois. Disorderly conduct.
Illinois.
One prior arrest, disorderly conduct.
Illinois.
Okay.
You ready?
Go ahead, Ms.
Mr. Baines, can you please raise your right hand? Do you swear or affirm the testimony she gave in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Please state your true, correct, and legal name.
Christopher Lewis Baines.
Did you say Lewis?
Yes.
Good. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, I'm not.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 33 and I completed 3 years of college.
Are you able to read, write, and understand the English language?
I am.
Do you understand that you've been charged with aggravated assault and aggravated battery being reduced by the state to aggravated assault being nullified by the state, aggravated battery being reduced to battery family violence?
Correct.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yeah, but hold on. As far as the battery family violence, I thought it was just battery.
It's battery family violence.
Okay.
Do you want to move forward with the plea?
Yes.
Okay. Do you understand that you've been charged with battery family violence?
Yes.
Okay. Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
Yeah, because I didn't know that it was going to be family violence. I thought it was going to be a battery. I didn't know. Can we drop the family
No,
violence just for battery?
no, it's either battery, family violence, or we're gonna move forward on aggravated assault, aggravated battery. It's your decision, Mr. Baines.
I just have a question as far as why wasn't that discussed in the deal? I was told it was battery.
I'm not sure why, but this is that I'm making the offer of battery, family violence, and it's your choice if you want to move forward or not.
We put it on the record before.
It's been on the record, right?
When we first talked about it before we went to break.
Mhm.
Oh, yeah.
I didn't hear the family violence part.
Okay, Mr. Baines, would you like to move forward or not?
Yes.
Do you understand that you've been charged with battery, family violence?
Yes.
Okay. Do you need more time to discuss this case with your attorney?
No.
I'm sorry?
Mr. Baines.
No.
Okay. Are you satisfied with her services?
Yes.
Mr. Baines, you gotta speak up.
I said yes.
All right, you're turning away from the microphone, so it's hard to hear.
Can you hear me
Counsel, do you waive from reading of the indictment?
Yes.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So wait.
Mr. Baines, have you been arrested on these charges?
Yes, I would. Wait, not previously, but currently.
Okay. I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Has your attorney advised you of the maximum sentence of 12 months to serve on the charge that you're pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months probation, special condition that you complete an anger management course or program, but the court does not have to accept that recommendation. The court can sentence you to the max, which is the 12 months to serve. Do you understand?
Can you repeat that?
Do you understand that the offer is 12 months to serve and you have to complete an anger management program?
I was understand that once I complete the anger management program.
Remember, I told you that I'd have to ask the judge for that?
I didn't.
Well, do you understand now, Mr. Baines, that the offer from the state is 12 months probation and that you have to complete an anger management course?
Yes.
Do you understand that the judge can then not accept the recommendation from the state or from your attorney and can sentence you to the max, which is 12 months to serve? Do you understand that?
Yes.
Okay. Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
I understand, but I'm sorry, but I do have to talk to my lawyer about this because I'm be honest with you. It seems like
We got other police.
I'm sorry. I'm sorry.
Okay, well, that's fine. Your Honor, can we just reset this case and?
It's ready for trial.
Yeah, we're done with the
Ready
record.
for trial. And get a trial notice, sir.
April the 14th, he needs to be here.
April 14th, you need to be here at the courthouse, ready for trial.
Okay.
Thank you, sir.
And there will be no plea.
Yeah, he just wasting time.
Well, I think they want to get rid of Mr. Farrell because they
I'm
want to
so
take.
sorry, sweetheart. Oh, of course. Oh.
Your Honor,
This
that
the last
concludes
one,
my
right?
business, and I be excused.
I got two, but this baby's been sitting here all day.
Right.
Really? What are we doing?
Is that Mr. Pearl, you know, what's he doing?
Mr. Farrell is entering a plea and Mr. Grady's entering a plea. They're both negotiated.
Okay, I'm sorry.
Because they want to take him down.
Fantastic, Mr.
So
North, why you did.
And maybe you'll give him a reduced sentence because of his patience back there. You signing, they're reducing count one, the criminal attempt. From the criminal, that makes you parole eligible. That is 10 years minimum. And still intend to serve 7. on the charges. You have to sign there.
Oh, it's number 36 on the problem.
Oh,
Number 36.
You wanna know what?
Judge, I don't have a calendar. You gotta give me names. What's the name?
Joseph Farrell.
Position number, yeah, position.
Wait, we're doing forever.
Oh, that one.
Omar Flores.
Wait, what is this?
Farrell.
This is Mr.
Okay. Oh,
Farrell.
This is number 5
Number 5.
on the plea and arraignment.
I need
Plea
names,
and trial.
please.
Joseph Farrell.
Joseph Farrell. I thought we already did that person.
No, we had to stop. Where did we stop, Ms. Sanders?
Litigation manager, this is actually a trial calendar the state was going to reinvent to add, interrupt, pushed out further. Once they call it out Monday, they won't have the time to, if they reindict, if we want to do, total finish, we need to serve 7. Possession of a firearm, which will be consecutive, so that will be consecutive 5 years, right? Probated, it's pursuant to subsection E, when it's out.
So it's now he's decided to plea, but.
That is
He already gave
correct.
his history. He only has that, Mr. Farrell. He's
Okay.
on the probation for the forgery and the 4th.
Okay. All right, go ahead, Mr. Brown.
All right. Mr. Farrell, please raise your right hand. Can you raise your right hand, sir? Thank you. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
You're gonna have to speak up. I know you can speak. You don't have to,
Yes.
but just speak up.
Yes.
There you go.
I'm gonna repeat. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Wow.
Yes.
All right, you can talk about it right there. Thank you. Put it on there.
State your true, correct, and legal name.
Joseph Farrell.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
25 years old.
And how far have you gone in school?
I've got a bachelor's degree.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you are charged with the following offenses? You're charged with armed robbery, criminal attempt, 2 counts, aggravated assault, 3 counts, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon.
Yes, sir.
Have you reviewed these charges with your attorney, and have they advised you about the potential minimum and maximum sentence for each charge you are pleading to?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Michael Norman, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Do you waive formal reading of the indictment, Mr. Norman?
Yes.
Do you waive any and all defects in the indictment, Mr. Norman?
For the purposes of the plea, so waived.
Have you been arrested on these charges?
Yes, sir.
The state is unaware of any outstanding warrants related to these charges. Do you understand do you or your attorney know of any outstanding warrants that are related to these charges?
No, sir.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 15 to serve 7, and that's for the count 1 will be reduced from armed robbery to criminal attempt to commit armed robbery, and then aggravated assault 10 years to serve 7. 3 counts, and then possession of a firearm during the commission of the felony, 5-year consecutive probated, and then possession of a firearm by a convicted felon, again, 10 years to serve 7, concurrent with counts 1, 2, 3, 4, and 5.
Yes, sir.
But the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other. Were you made aware of the state's offer?
Yes, sir.
Do you understand that if your guilty plea, oh, my apologies. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? That this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 5 years in prison.
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights? The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney and at trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, excuse me, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges of criminal attempt to commit armed robbery,
Guilty.
aggravated assault,
Guilty.
aggravated assault,
Guilty.
aggravated assault,
Guilty.
possession of a firearm during the commission of a felony,
Guilty.
possession of a firearm by a convicted felon?
Guilty.
And those are all charges on indictment number 24SC004828. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
Your Honor, if this case had gone to trial, the state would anticipate that the evidence would prove beyond a reasonable doubt that on August 7th, 2024, officers responded to the paleo massage therapy at 195 Cliftwood Drive in Sandy Springs in Fulton County in reference to an armed robbery in progress. Officers were told that a Black or Hispanic male robbed at gunpoint and was still on scene at the location. Upon arrival, officers met with 3 victims, Mai Ramey, Mai Park, and Jenny Wang. Now, I can spell them for you. For the record, Mai, M-I, Ramey, R-A-M-E-Y. Victim 2, Mai Park, M-I, Park, traditional spelling. And Jenny Wang. They explained the accused, Joseph Farrell, came to the location wearing an all-black and carrying a black backpack. They refused service to Mr. Farrell several times due to his dress in all-black apparel, but he returned a short while later. Service was again refused, and the third time he returned, he was permitted to get a massage. While receiving services, he asked if there was anything else that they could do, implying happy ending, which the victims promptly declined and returned his money. My Park then escorted him to the front of the business and gave him the refund and asked him to leave. Defendant Farrell returned, stating that he left something in the massage room and was told that the room was cleaned and nothing was there. He then left the establishment and came back to the business with a shiny pistol. He yelled at my Ramey, Ramey, and pointed his pistol at her and requested that she give him all of her money and phones. Ramey stated that she did not have any money. He then went down a long hallway to Jenny Wang, victim number 2, and began yelling at her again, requesting money and phones. While in her presence, he took 3 cell phones that were on a table belonging to her and Paleo Massage. My Ramey ran out of the business and flagged down a vehicle whose driver called 911 for her. Farrell went through the business looking for all parties present, requesting money and phones. My Park was another employee in the business at the time. Farrell was described as stocky, 5'3", black or Hispanic male in his late 20s to early 30s with a tattoo of a bullet on his left forearm. He was wearing a black sweatshirt, black pants, black shoes, and a black hat, carrying a black backpack. While processing the crime scene, Mr. Farrell was located and arrested. Mr. Farrell had a black backpack that contained a handgun, a black sweatshirt, a black hat, a knife, a wallet containing his GA ID, and miscellaneous cards, pre-tied zip loops, a pair of gloves, and other miscellaneous unrelated items. Mr. Farrell was questioned and stated that he stashed the phones in a bush near 201 Allen Road. Officers went to the location and confiscated the phones. The state and defense have agreed to the plea agreement, and
Your Honor, we just ask you follow the plea agreement as stated. Although there was a weapon involved, no one was injured, and there were cell phones which were recovered the same day. And so I'm asking you to adopt the recommendation for Mr. Farrell.
Great, so we'll adopt the recommendation, add stay away from 195 Cliffwood Drive in Atlanta, Georgia. Stay away from My Ramey, Jeannie Wayne, My Park.
Yes,
My
yes, Your Honor.
Park. Have no contact with any of them, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Where are you gonna live, Mr. Farrell? You gonna live in Fulton County when you get out?
When I get out, I'll probably, or I can move.
All right, so I'll accept the recommendation, file that you please, freely, voluntarily, and completely knowing what you're pleading to in the sentence. Thank you. Best of luck to you.
Mr. Grady is ready. And I will call you later on. Go over everything, make sure you understand it. You didn't.
He gets ready for
Thank you.
Thanks, Chris, for your time.
Sorry.
Miss Grady's first name?
Joshua.
Grady.
Joshua Gray.
Yeah, I appreciate you facing me. You guys have done an interesting day today. Let me have you sign.
Sorry? Let's get in touch. I still want to.
Oh, wait. Were you going into the Army?
Yes.
Wait, I'm sorry. We have to reset this. I apologize. He didn't remind me. This is the Army guy. He's got his sign up for the, we can't take the plea today. I'm sorry.
Who is this?
We were here before. This is the gentleman that's going into the Army. He was supposed. Yeah, the state had agreed.
Give him a GD.
The state had previously agreed that they would reduce the charges if he was going into the Army and could prove all of that. And so Yeah, no, so he didn't mention, I completely forgot that this is who this was. And so he's been sitting here all day and never mentioned it
Oh,
to
good,
me.
you're gonna get you to the Army, hurry up and wait.
Yeah, I apologize, Your Honor, and I apologize to you, Mr. Grady. Had you reminded me of that out there, you wouldn't have been here
So
all
what we
day.
gotta do now?
We have to wait for him. I think he has
We
to
gotta take
get,
the ass back, right?
he got,
Take a test, 'cause what's the position just?
He got his GED. He had not even, he had.
no,
not-
he's taking classes for
Yeah.
at Atlanta Tech.
He going in,
Well,
When
he
I'm
has,
going there?
huh?
Well, I graduate June, so I see by August.
In August, right?
Yes.
well, he has to graduate in June and he has to take the ASVAB. So we have to reset this to after that. I completely apologize, Your Honor, and Mr. Grady.
When is graduation?
June. I see your email. I still got it.
You got my email?
Yes.
So, probably like September, October.
I want to be invited to graduation.
I still got your card.
Okay.
You had to see how, why didn't you remind me that I see so many people, I forgot that this is who this was. That's him.
Don't change your mind, Judge. Wow.
No, wait a minute.
It was in August.
June.
I'm looking at you.
What?
Oh, no, we're done, but I'm looking at you for another reason. We're done. Can I talk to you about
Yeah.
the June day?
Okay. So, how we gonna set it up? Like,
Ma'am, I'm gonna set it.
That's it?
that's it, Boston.
Y'all owe me.
All right, thank you, Boston.
Y'all have a good one.
All right, you too. Have a good weekend.
Thank you, Boston.
Yeah, who said that?
It's 88 Brown. I didn't even know it was possible. I said, wait a second, they're getting criminal histories.
You're welcome.